One
Page
Maybe
one.
after before vacation.
before vacation.
Or after fresh admission na after notice?
No, after notice my lord.
After notice before notice केमती नहीं होगा आपण माने अपेक्षा करी रहिथिले ना कोन को मसियार मैटर
The 2026.
बोले तापर अर्जेंट ठीक अछि yes
Page one, 2 to 8.
yes
Page two, 9 to 20.
My lord, item 10 may be taken up after vacation.
after vacation
My-
then Mr. S.K. Dwivedi for the petitioner the matter being listed for fresh admission is mentioned by the lauded counsel for the petitioner at the beginning of the day's proceedings seeking adjournment stop matter was earlier had at length on 10/3/2026 facts and the legal issues were noted stop thereafter it was adjourned on stop to grant further opportunity to the petitioner based in the week commencing on 29/6
My-
Item 9 also same prayer, my lords, may be taken up after vacation.
after 9 will Miss Pratyusha appearance in
Madam.
matter being in the list mentioned here fresh admission earlier had jota length hochi 2/2/26 adjournal 22/4/26
Item
9, 10.
2, my lord.
okay 9 date कहले नि
We comment it.
हैं
29.
ठीक अछि 29/6 आपण
Right, my lord.
yes sir
Item 9.
9 and 9 Mr. DN Lenka for the AGA for the OP
Item 2, my lord.
2
Yes.
के कोई बात 2 कोण है
Praying for adjournment. Sir, withdraw I had a withdraw, my lord. 102/21.
ते विथड्रॉ हे परियो डिस्पोज ऑफ हेजो
Yes, sir.
आई विथड्रॉ करे पे आप सीनियर कहले
Sir, I had a खाली withdraw. जो did I.
डिस्पोज ऑफ हेजो जेटा बांकर नोट हबो जे डिले नाही बोली
Yes.
सेटा विथड्रॉ पाई त आपण तो जेटा अलगा प्रेयर एडजर्नमेंट हो अलगा प्रेयर
Dispose of करो.
या आप प्रेस एंड मैटर रे कोन आर्गुमेंट करिवे नि एडजर्न करिवे
Yes, sir. Ebe adjournment
जाउ छ एडजर्न
after vacation.
सेम आपण ना सर
Power नहीं.
पावर नहीं किंतु आपण ना हो पावर नहीं दास ना कोन
अनुरुद्ध दास करो. On behalf of अनुरुद्ध
आपण
दास.
अनुरुद्ध दास ना देखा जो नांती लोन ना कोन टेल योर नेम सर पावर नहीं को कि अनुरुद्ध दास नो
Subhranshu Jena.
Mr. Subhranshu Jena on behalf of Aniruddha Das केबे कोर्ट रे कहबे नि पावर नहीं काहे ना यू आर रिप्रेजेंटिंग द क्लाइंट प्लीज अंडरस्टैंड द ब्रॉडर पिक्चर कोन पावरलेस हेले केमति हो पावरफुल है on behalf of Aniruddha Das है the matter being in the list for fresh admission same prayer hard at length on 9/4/2026 ना that's some that's a probably defect भी remove it oh the Lorded Counsel for the adjournment is one line the adjournment is sought for on behalf of the Lorded Counsel for the petitioner as prayed for the matter shall be listed in the week commencing
29.
29/6/2026 yes
Number 4. Yesterday only I received a copy.
four sir four
Yes.
madam dei अछंती
Yes.
Copy.
four Anima Kumari dei for the petitioner आपन को ना सर
Sanjay Kumar Das.
So Sanjay Kumar Das, Standing Counsel Vigilance. Standing Counsel Vigilance for the opposite party. Copy of the application has been served on the Learned Counsel for the Standing Counsel. It is to matter being in the list at first like that. Matter being in the list is mentioned by the Learned Counsel for the petitioner as well as the Standing Counsel. Copy of the application has been served on the Learned Standing Counsel yesterday. The matter shall be listed for fresh admission in the week commencing after vacation.
Yes.
6 7.
6/7/2026
Page 3, 21 to 26.
9 to 20 के mention sir 21 to 26 yes
Page 4, 27 to 29.
27. Taken up after
so
vacation.
के Behra for the petitioner opposite party Mr.
For opinion number 3.
No, no object.
then that posting कर दियो after notice better date करो तो
We come in 13 7.
yes
29.
27 Mr. Lenka ଆପଣଙ୍କ better fair ଥିବ ସେ ପାର୍ଟି ଅଛନ୍ତି ଖାଲି ମିଷ୍ଟର ମହାନ୍ତି ନୋଟ କରିଦିଅନ୍ତୁ 13 ସାତ yes
29.
29 yes 29 ଡେଟ୍ କରନ୍ତୁ
We can see 13 sir.
yes
Page 5, 32, 36.
30 ରୁ 36
Item 36 will objection not filed by the opposite parties.
ଇଏ କଣ ଆପଣଙ୍କର କଣ୍ଡୋନେସନ ପାଇଁ
No, my lord. It is admitted and issue notice and stay is there.
ଟ୍ରାନ୍ସଫର ଆପ୍ଲିକେସନ
Yes, ma'am.
ଅଦର ସାଇଡ୍ ଅଛନ୍ତି
Opposite party को ମୁଁ
ଟିକେ ଖବର ଦିଅନ୍ତୁ
communicate କରିଥିଲି ma'am.
ଆପଣ ତ ପୁରା ଷ୍ଟାଇଲିଶ ଲାଗୁଛନ୍ତି
No, sir. But
ଆର୍ଗୁମେଣ୍ଟ ବି କରିପାରିବେ
viral infix.
no I good looking good sir
Your Lordship, I am appearing on behalf of item number 36, opposite party.
ଯାହା କହୁଥିଲି ସେ ହେଲା I didn't know this she is there she is objection ଦେବେ
Your Lordship, I will file it by tomorrow.
ନାଇଁ ତୁମର କଥା ନାହିଁ ଆପଣ ଦେବେ ତ
Again, Devi again.
ଠିକ ଅଛି ଆଫ୍ଟର ଭେକେସନ ନା ବିଫୋର ଭେକେସନ
Before vacation. I'll file it by tomorrow, Your Lordship.
ବିଫୋର ଭେକେସନ ଲିଷ୍ଟ ହବ ଆଫ୍ଟର ନୋଟିସ
Yes, no, Your Lordship, kindly list it matter before vacation.
ଠିକ ଅଛି
No, no, I'll file the rejoinder after.
ସେଟା ଭାବୁଛନ୍ Anyway,
Let
yes.
it be. Let it
ଡେଟ୍
be.
କରନ୍ତୁ ସାର୍
We can see 18, 5.
18/5 ଆସୁ ଦେଖିବା
My lord,
18/5 ରେ 100 ଅଛି ବୁଝିଲେ କି ଅଲରେଡି वी हैव क्रॉस्ड 100
interim order to be continued.
ଏଣ୍ଟ୍ରି ମର୍ଡର ଟଚ୍ କରା ଦେଖ ଆଡଜର୍ନମେଣ୍ଟ ଥିଲା ନା କଣ ଅର୍ଡର କଣ ଥିଲା ଏଣ୍ଟ୍ରି ମର୍ଡର ଷ୍ଟେ
Again.
It was
It's not being touched.
Okay.
Please appreciate that.
Page 6,
Item number 33, Arjun. After
33 madam, yes.
after action,
ଆପଣ ଅଦର ପିଟିସନର ଅପୋଜିଟ୍ ପାର୍ଟି
petitioner.
ଅପୋଜିଟ୍ ପାର୍ଟି କହିଲେ ଖବର ଦେଇଛନ୍ତି
Full.
ଇନଫର୍ମେସନ ମହାପାତ୍ର ଠିକ ଅଛି 33 ଡେଟ୍ କରୁ
we can see 13 sir.
13 ସାର୍ yes
Item number 40. Here, my lord, first order regarding addition of party that has been rejected. Accordingly, it is filed by order dated
2025 ମ୍ୟାଟର ଏଟା ତଳକୁ ପଳେଇ ଆସୁଛି ତ ଏଟା କଣ ଆପଣ ଚାହୁଁଛନ୍ତି ବିଫୋର ଭେକେସନ ହିୟରିଂ କରିବା ପାଇଁ?
ନାଇଁ before after vacation ଆସୁ କିଛି ଆପତ୍ତି ନାହିଁ କିନ୍ତୁ ଇଏ ଲକ୍ଷ୍ମୀ କାଲି order dated 27/2026.
Just once. Mr. Ray, you are not appearing here.
No.
Mr. Mahantikar, Dwarika Prasad Mahantikar chamber is here, sir. Tarashan. Mr. Paisa, you are there in this matter?
No, my lord.
40.
Item 7.
अच्छा नहीं ठीक है ताले केही भी appear करो.
ଏଥିରେ ଅର୍ଡରଟା ହେଇଥିଲା
Just
ଫାଷ୍ଟ
Just give me a second, I'll get the file.
23/12/2025 ଏବଂ 27/4/2026 ଅର୍ଡର ଆଜ୍ଞା ଟିକେ ଦେଖନ୍ତୁ 1/5 ରେ ଥିଲା।
Addition of parties को object court reject कर देले. कोर्ट
आगे.
ground रे माने necessary की ये पार्टी नोती होना.
କିଛି କହିଲେ ଦି ପୁଅ ଆଜ୍ଞା ବଡ ପୁଅ ରିଟାୟାର୍ଡ ଗଭର୍ଣ୍ଣମେଣ୍ଟ ସର୍ଭେଣ୍ଟ ବଡ ପୁଅକୁ ମା ପାର୍ଟି କରିକି ମେଣ୍ଟେନାନ୍ସ ମାଗିଲେ ଆମେ ପିଟିସନ ଦେଲୁ ସାନ ପୁଅକୁ ମଧ୍ୟ ପାର୍ଟି କରନ୍ତୁ
ये तो बहुत पुराना केस.
ଆଜ୍ଞା
ଏଟା ଆଉ କୋଣ ଏପର୍ଯ୍ୟନ୍ତ ଚାଲିଛି.
ନା ୟୋର ଲର୍ଡସିପ ୱିଥ ଅନରେବଲ ଜଷ୍ଟିସ
Division
ସିହ୍ନା
bench ଥିଲା.
ରିମାଣ୍ଡେଡ ଦି ମ୍ୟାଟର ଦେୟାର ଆଫ୍ଟର ଇଟ ଇଜ କଣ୍ଟିନ୍ୟୁଇଂ
କେବେ ଗୋଟେ ଡେଟ୍ କରନ୍ତୁ ଆଉ କଣ.
ଜୁଲାଇ ପରେ ହଉ ତାପରେ ଯେମିତି ଡେଟଟା ରଖିବେ ତଳକୁ ଆଜି ଅଛି ଡେଟ୍ ଆଜ୍ଞା
Acha, the matter is being in the list for hearing under the heading for admission. It is important sir inform करेगा. When you are seeking adjournment, all the
କହିଦେବି ଆଜ୍ଞା।
ସେ 3ଟା 8ଟା ବେଳକୁ ଆସି
ଆଜ୍ଞା, ଆଜ୍ଞା। ନା ମୁଁ ଇନଫର୍ମ କରିଦେବି
sorry. Is mentioned by the Lorded Council. ଆପଣଙ୍କ associate sir ମାନସ ରଞ୍ଜନ ବାଗ.
ଆଜ୍ଞା
Vanshidhar Bag, senior counsel for the petitioner, along with Mr. Manas Ranjan Bag for the, along with Mr. Manas Ranjan Bag. Opposite party black link, non-bookable. The matter being in the list for hearing under the heading for admission is mentioned at the beginning of the day's proceeding by the learned senior advocate. Stop. It is submitted that the date of the next date of listing before the learned judge, learned trial court, learned Judge Family Court Balasore.
ବାଲେଶ୍ୱର
Judge Family Court Balasore is on.
ଆଜି ଅଛି ଆଜ୍ଞା ମୁଁ ଦଉଛି ଏଫିଡେଭିଟ ଟା ବି ଦେଇଛି
Is first 5 5/20/26, that is today. Stop. He submitted that during pendency of the present application, the learned court, the matter may be adjourned before the learned trial court. Stop. Accordingly, it is directed upon a prayer being made before the learned judge family court. The matter shall be prayer କରିକି adjourn କରୁ.
ହଁ ଜୁଲାଇ ପରେ ଜୁଲାଇର ଏବଂ ତା ପରକୁ ଗୋଟେ
The matter
ରଖିବ
shall be adjourned to a date beyond 13/7/2026.
ଆଜ୍ଞା
The matter as would be convenient to the learned court in season of the matter.
ଆଜ୍ଞା
10/7/2026 as would be convenient to the learned court in season of the matter. The matter shall be listed on in the week commencing 6/7/2026. Yes. ଆପଣ ଗୋଟେ affidavit ଦଉଛନ୍ତି.
ଦଉଥିଲି ଆଜି ଅଛି ବୋଲି ସେଇଟା
Affidavit filed by on behalf of the petitioner indicating the listing date of the matter before the learned judge family court is filed in court. Same shall be taken on records. Scan copy of it.
Item number 13.
Yes, please.
My friend has filed the after affidavit. Both are special.
39 sir ଆପଣ ଅଛନ୍ତି.
Yes. I'm appealing on behalf of copy number 4. I have filed a
39 the state ଅଛନ୍ତି.
consumer
କେବେ after vacation?
after vacation.
39 date କରିଦିଅନ୍ତୁ.
Immediately after vacation. So that can be
Yes, ତ ପ୍ରାୟ sir.
we come in 6.
Yes, possible
I have filed the Bhoklasnama. Now counter is there, but by mistake my name is not appearing. So because perhaps it is in
ଗୋଟେ
the
ଲେଖିକି ଦେଇ ଦିଅନ୍ତୁ ଗୋଟେ କାର୍ଡ. ସେଟା verify କରିବ. Date
copy number 4.
Date କରିବ. କେବେ date କଲେ?
we come in 6.
Okay.
Item 30.
30 sir.
38.
38 sir.
Madam, after vacation, madam, in the meantime, we will file count.
38 ଟାକୁ date କରିଦିଅନ୍ତୁ.
41 also.
41 also. 41 ରେ power ଦେଇନାହାନ୍ତି?
Nine ଆସିନି instruction.
କରନ୍ତୁ. In the meantime, it is
Yes, ma'am.
complete.
Madam,
38 date କରନ୍ତୁ ଆମେ କରନ୍ତୁ.
we come in 13/7.
13/7/41.
we come in 13/7.
apply.
Item
37.
ଆଜ୍ଞା
37.
37 yes.
Affirmative.
ଆପଣ yes for petition.
We come
37 date କରିଦିଅନ୍ତୁ other side inform କରନ୍ତୁ.
13/7.
We come in 13 Mr. Baisa. Yes please.
Item number 28.
Yes.
Application consent to file wakalat number does not.
ଆପଣ other side को ଟିକେ inform କରନ୍ତୁ. After notice matter.
ଆଜ୍ଞା.
କେବେ after vacation?
No.
Before vacation?
Thing is, they have not paid the increment for a very long time. Since
well, ଆଜି ଥାଉ ଯଦି ସେ ଆସିବେ ତାହେଲେ ଆପଣ mention କରିବେ. Just wait for the other side. You are for the opposite part. Okay. देखो नॉले just inform the other side. Yes, next.
Item 1.
For नांदी कुछ जल्दी.
The names for the substitutes are not taken.
Not taken. So, yeah, whatever that.
Last 3 to 4 occasions they have not been appearing. Madam. Last occasion, Mr. P.R. Behra was appearing.
Appellant none. The Prem Kumar Mahanti, additional standing counsel. For R1 and 2. So they can on the along with G and Sahoo for OP R3.
R4 madam.
गोकुल पे आपण अपेयर करनांती
ना ना आमे अपियर करनु मैडम
गोकुल पे आपण सबळे अपेयर करछन सब मैटर इथरे
ना 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 गोकुल पई आउ जने अपियर करथले दैट मैटर हैज बीन डिस्पोज्ड ऑफ बाय अस जारी पे
आपण भी गोकुलानंद ना
मैडम
ते मो सेटा मन रह गेला से जो ई वर्ष तळे आला आपण निजे गोकुलानंद है कि गोकुल केसटा गला पूरा तार पुडे देले ता केस R4 R3 none, R4 Mr. Vikananda along with Mr. Jain Sahoo. None appears for the petitioner when the matter is called. On 7/4/2026, Sahoo likhi the matter is listed for mediation. On 7/4/2026, the matter was adjourned at the instance of the learned counsel for the petitioner. On 26 none had appeared for the appellant. Who petition to the appellant? Appellant. 16 and 26. No, none had appeared for the appellants. The matter is kept pending since 2015. The appeal is kept pending since 2015. The Learned Additional Standing Counsel as the Learned Counsel for the R4 mentioned that the appellant is not serious in prosecuting the matter. So, after vacation anyway, before vacation? After. The matter shall be listed in the week commencing. Now, 18 week देखिए. Under the same heading in the week commencing 18 indicating that it is to be disposed of. Likely it is to be disposed of. A copy of this order shall be forwarded to by the registry to the Learned Counsel for the appellant. Yes.
Item 3.
Your Lordship, I am behalf of
A.
S. K.
Nanda.
Nanda.
This is A. Nanda on behalf of. You
I
have
pre-
power here?
No power.
No power. Sorry, आपको नाम
Soumya Sucharita Pradhan.
This Soumya Sucharita, MS Soumya Sucharita
Pradhan.
Pradhan on behalf of S. K. Nanda for
I pray for adjournment.
the petitioner. Adjournment is sought for on behalf of the petitioner. The matter was heard at length on 23 The facts and the legal issues involved were noted in the order of the said date. Thereafter, it was adjourned by the petitioner on 16/4/2026. Stop. To grant further opportunity to the petitioner list in the week commencing on 6/6/2026.
Grateful.
Item 5.
6/7 ଆଜି କେତେଟା ରଖିଲେ? 6/7 you are approaching 70.
May I please, your lords.
Mr. Manojan Padi for the petitioner. Yes, please.
My lords, I am challenging the judgment dated 23/26 passed by the family court, my lords. It is awarded the monument 6,000 for month, my lords.
So have you examined the pleadings and the evidence?
Yes, my lords.
So please straight away come to the pleadings and evidence and argue on the merits. What was
In
your
this
case?
case, a small player, man. In this
No, no.
case, man, there is a chance.
The smallest thing you have to do, even smaller than the small
No.
prayer, is that confine. Read. You must understand that it's a revision.
Yes,
So
sir.
please confine to the pleadings and the prayer before the trial court
Yes, sir.
first, and
Yes.
then how the trial court has erred in
Yes, sir.
appreciating that.
Yes, my lords. Well, come to the, my lords, page number, the judgment, my lords, page number 12, my lords.
Judgment pleading.
Yes, my lord.
ମାନେ ଆପଣ ଅପୋଜିଟ୍ ପାର୍ଟି ଥିଲେ,
Yes, my lord.
ଆପଣ ରିଟିନ୍ ଷ୍ଟେଟମେଣ୍ଟରେ କଣ ଷ୍ଟାଣ୍ଡ ନେଇଥିଲେ,
Yes.
ଏଭିଡେନ୍ସ ଦେଇଥିଲେ,
Yes, my lord.
how it was appreciated by the learned trial court,
Yes.
and why the trial court faltered or whatever you are saying.
Yes, my lords. Come to the page number 30,
ଦେଖିଛନ୍ତି ଆଗ
36.
ଆଗ ରିଟିନ୍ ଷ୍ଟେଟମେଣ୍ଟରେ କୋଉ ଷ୍ଟାଣ୍ଡ ନେଇଛନ୍ତି ଆପଣଙ୍କର ଷ୍ଟାଣ୍ଡ କଣ ଥିଲା?
Yes, my lord. My stand is that, my lords, the petitioners now the jobless, my lords. First things. And
ସେଟା ଦେଖନ୍ତୁ ରିଟିନ୍
yes,
ଷ୍ଟେଟମେଣ୍ଟ ଦେଖନ୍ତୁ,
Yes,
ଜବଲେସ୍
sir.
ହେଲେ
The second thing-
ଦେବେନି,
yes,
ଆପଣ ଜବଲେସ୍ ହେଲେ
Yes, sir.
ଡେଲି ୱେଜ୍ ହିସାବ କରିବେ, ଡେଲି ୱେଜ୍ ବର୍ତ୍ତମାନ ଧରନ୍ତୁ 800 ଟଙ୍କା, ତାହେଲେ 24,000 ଟଙ୍କା, ତେଣୁ 6,000 କି 700 ଟଙ୍କା ହେଲେ 21,000
Yes, sir.
ଟଙ୍କା। ତ 21,000 ଟଙ୍କାରେ 6,000 ଟଙ୍କାଟା ବେଶୀ ନୁହଁ। ଆପଣ ଯଦି ଜବଲେସ୍ ହେଇ ନଥାନ୍ତେ ତାହେଲେ ଏବେ ତ ଆପଣଙ୍କ 10,000, 15,000, 20,000 ଟଙ୍କା ହେଇଥାନ୍ତା ମେଣ୍ଟେନାନ୍ସ।
and the second thing, sir, she is
ଆପଣ
not
କୋଉ
produced
ଡିସିସନ
any.
ପଢିଲେ? ଏଇ ଯୋଉ ଜବଲେସ୍ ରେ କୋଉ ଡିସିସନ ପଢିଛନ୍ତି?
And
ଜବଲେସ୍
I'm
ହେଲେ ଦବାକୁ ପଡିବନି ବୋଲି ପଇସା ମେଣ୍ଟେନାନ୍ସ ଦବାକୁ ପଡିବନି।
no, because one judgment is my our High Court, my lord.
ଆୱାର ନାହିଁ, ଆୱାର ସୁପ୍ରିମ କୋର୍ଟ।
My lords,
ଆୱାର ସୁପ୍ରିମ କୋର୍ଟରୁ କୋଉ
the wife
ଜଜମେଣ୍ଟ
is
ଜବଲେସ୍ ଥିଲେ ଦବାକୁ ପଡିବନି।
the wife is nice, same.
ପଢନ୍ତୁ।
Yes, sir.
ପ୍ରୋବ୍ଲେମ କଣ ହଉଛି କହିଲେ, ଆପଣ ନିଜ ଏଗେନ୍ଷ୍ଟ ଆର୍ଗୁମେଣ୍ଟ କରୁଛନ୍ତି। Jobless is not a valid ground for non-grant of payment. If somebody is able-bodied, so ଏଟା ମୁଁ କିଛି ନୂଆ କରି କହୁନି।
No.
ମୋର ତ ସେମିତି କେସ୍ ବି ନାହିଁ ଯେ ମୁଁ ଜଜ୍ ହିସାବରେ ଯେତିକି ପଢିବା କଥା ପଢୁଛି। ଆପଣ ଗୋଟିଏ କେସ୍ ଆର୍ଗୁମେଣ୍ଟ କରିବେ, ବିଲକୁଲ ପଢିବେନି। ଜବଲେସ୍ ଆର୍ଗୁମେଣ୍ଟ ହେଇପାରିବ କି ନାହିଁ? ଜବଲେସ୍ କୋର୍ଟ
And
ରିଟିନ୍ ଷ୍ଟେଟମେଣ୍ଟ ଦେଖାନ।
My lord, second things is, my lord,
ଗୋଟେ
yes, sir.
ଜମ୍ପ ଆରାଉଣ୍ଡ।
Yes.
Jobless जो written statement देखा तो
दो अच्छे से Let's say I filed the page 36, my lord. My evidence affidavit, my lord.
बड़ा written statement को ले evidence को पढ़े written statement रे अपन jobless बोली कोर्ट देखी so that you will substantiate with evidence
Those.
अपन को written statement 28 ରୁ 32 28 ରୁ 32
Yes, my lord.
तू assist कर जल्दी हो spending time
Page 31H.
correct age टा पढ़ो
That is pertinent to mention here that before the marriage, the OP was working under a contractor as supervisor at Duburi and earning 12,000 per month. Now, after desertion of his wife, he mentally shocked and moving her and there for which he lost his job since 2025.
evidence कौन होते हैं mental shock और ये
Yes, ma'am.
mental shock है गला बोले evidence कौन होते हैं इंग्लिश तो भूल भाल लिखिले
Sir, I mean, Tolo court, sir.
अरे सर आपण को कोई भी ना कहा कोई भी आपण लिखिले माने आपण को क्लाइंट है ही मेंटली शॉक रो अर्थ कोन ही मेंटली शॉक को हम प्रूव भी कर परियो ना ओटे ठीक कथा लिखिले ही कोन कोन एविडेंस कला आपण एच रे लिखिले जे
Yes, ma'am.
आपण 12,000 आपण को प्रॉब्लम कोन हला जे आपण अनविटिंगली आपण को कैपेसिटी टू ऑन भी आपण लिखि देले आपण बाहर केबे हेतला
बाहर मतलब से 23 14/7/24
24 मसेरे आपण 12,000 टका पाउतिले तो एटा 25 मसेरे आपण किछि पाइबेनी बोल तो आपण अर्निंग कैपेसिटी अछि बोले आपण कहि देले ठीक अछि एविडेंस देखा
evidence sir.
एविडेंस इन चीफ
My lords, page 33. Answer 4.
हां देखा बोलते कोन अछि
मतलब para 8 my lord, 35 my lord. That the pertinent
33 रे कहा एविडेंस देखछु
the more
कोन ना कोन
Bapuji Raut.
33 पढो रे ऊपर
Evidence affidavit filed under order.
अरे नाटा कहबे ना बापूजी रे एविडेंस
Sir, Bapuji Raut.
33 आपण को
Page 33.
33 देखिए मोर के मिसुन तो आउट कर
Sir, double easy.
तो सीधा पेज मार्क बोलतो
Se extra down.
हो मिसुनी अपन देखि कोन करो यूं तो ये आपण भी आपण को 33 रे मो 33 मिसुनी आपण को 33 बाबाजी मो 33 अनादि अनादि कोन एविडेंस देले ठीक है 36 पेज 36 रे दीप सर को दियन फाइल दे बापूजी अनादि एफिडेविट कोन काई देले ठीक है
Says father my lord.
ताकू के आनले
That is
माने जहा को जो कले कले बापन को बेणी
is filed.
कोडी कोन ना
Yes, ma'am. Page para 8 my lord.
पेज 38 रे सेटा आपन को पेज रे कहि परिबे
Mar 35.
सेटा इंटरनल पेज रे थिबो लास्ट हां
38.
ହେଲା ଏଇଥିରେ ସେ ଲେଖିଲେ ଯାହା କହିଲେ ଅବଜେକ୍ସନ ରେ ସେଇଟା ଜଜମେଣ୍ଟ ରେ କୋଉଠି ଡିଲ୍ ହେଇଛି ଦେଖ
Judgment, my lord. Yes, my lord. Page, page to mission, page 19. Inter page 7. 19.
ନାଇଁ ଆପଣ ପେଜ ମାର୍କ ଆପଣ ମିଶୁନି ଆପଣ କହିଲେ ପାରାଗ୍ରାଫ ଟା କୋଉ ଜଜମେଣ୍ଟ ର କୋଉ ପାରାଗ୍ରାଫ ରେ
Paragraph 11, my lord. No, 12,
Yeah.
12, 12,
ନାଇଁ 11
No.
ଠିକ ଅଛି 11 ରେ ଡିଲ୍ ହେଇଛି 11 ରେ ପଢନ୍ତୁ
11 minutes. The counter affidavit of OPW1, that PW1 surprisingly left his house.
affidavit no counter evidence
Again?
again हो counter evidence को affidavit पढ़िए
The counter evidence of PW1.
ଆପଣ affidavit पढ़िए
Yes.
ବୋଲେ ଆଉ ଗୋଟେ କଣ ପଢୁଛ
That
ପଢନ୍ତୁ ଠିକରେ
P-
ପଢନ୍ତୁ
The counter evidence of OPW1, that PW1 surprisingly left his house on the fourth night of their marriage and she was found naked in her room on such occasion are appearing to be unbelievable. In this cross-examination, she admitted that consequent upon the solemnization of marriage with PW1, they cohabited in his house for 1 month and 10 days, and other factual circumstances elicited from his mouth are not so much substantial in support of his evidence in chief. Therefore, he has uh, designed a false defense to nullify the impact of a well-structured case formulated by PW1 to secure maintenance from him. It is also worth mentioning that the case for restoration filed by him against PW1 by CP number 294/25 has been dismissed by this court. Thus, it is held in such factual circumstances that PW1 is entitled to maintenance from the OP1.
12 पढ़ो
12 minutes. Now questions revolves around how much equitable maintenance needs to be awarded in favor of the PW1. In this regard, PW1's assets that OPW1 is earning 60,000 per month as a labor contractor cum supervisor at Duburi, which is
ଦୁବାଇ ଦୁବାଇ
sir Dubai no sir Duburi ho sir.
ଦୁବୁରିରେ ଦୁବାଇ ହେଇଯାଇଛି ଆଉ
Sir, that Duburi sir. Duburi, which is contradicted by OPW1, but such evidence is confirmed by her in her disclosure affidavit of assets and liabilities, whereas OPW1 mentioned that PW1 is earning 10,000 per month in her such affidavit, synthesizing all such evidence and exigence of granting maintenance
ଆପଣ
in
ଯୋଉ ଡୁବୁରିର କ୍ରସ୍ ଏକ୍ସାମିନ୍ କରିଛନ୍ତି ୱାଇଫ କୁ କଣ ପଚାରିଥିଲେ ୱାଇଫ ର କ୍ରସ୍ ଏକ୍ସାମିନେସନ ଦେଖା
ସେଟା ମାନେ
ସେଟା ପଢିବେ ନା କିଛି ନାହିଁ କେସ ରେ କିଛି ନାହିଁ
ସେଟା ବି ସାର୍
dismiss ହବ ନା କୋଉ ଦିନ ଡିସମିସ୍ ହବ
ମାଲର୍ସ
ଆଜି ଡିସମିସ୍ ହବ କେସ ଆପଣଙ୍କର ନା କୋଉ ଦିନ ଡିସମିସ୍ ହବ
compromise sir there is a chance of
ପଇସା ଆପଣ ଦେବେ ଆଫିଡେଭିଟ୍ ପଇସା ଯଦି ଆପଣ ମୁଁ ଦେଇପାରିବିନି ପଇସା ପଇସା ଦବା ନବାରେ ମୁଁ କଣ କମ୍ପ୍ରୋମାଇଜ କରିବି
sir
ଜଣେ କହିଲେଣି
the
OTS
documents the wife not say single documents are produced regarding the income of the husband but
ପଢିଲେ ସାର୍ ବର୍ତ୍ତମାନ ପଢିଲେ
Yes, sir.
ଆପଣ ଯଦି ଏବେ କହିବେ have to reject
No,
that
sir.
you are being watched ଆପଣ ୱାଇଫ କୁ ଏଭିଡେନ୍ସ ପଢିଲେ ବର୍ତ୍ତମାନ ନଟ୍ ଏ ସିଙ୍ଗଲ ଡକ୍ୟୁମେଣ୍ଟ ସେ ଏଭିଡେନ୍ସ ଆଫିଡେଭିଟ୍ ଦେଇଛନ୍ତି
they just
ଆସେଟ୍ସ ଆଣ୍ଡ ଲାୟବିଲିଟି
sir
ତ ଆପଣଙ୍କର ତାଙ୍କର ପ୍ରୁଫ କରିବା କଥା ଯେ ନେଗ୍ଲେକ୍ଟ ଇଜ ଏନଫ୍
yes
ଆପଣ ଯଦି ଅର୍ନ କରୁନାହାନ୍ତି
Sir.
ୟୁ ହାଭ ଟୁ ପ୍ରୁଭ ଦ୍ୟାଟ୍ ବଟ୍ ଆପଣ ନିଜେ କହୁଛନ୍ତି ଯେ ଆଜ୍ଞା ମୋର 12,000 ଟଙ୍କା ମୁଁ ପାଉଛି ସୁପରଭାଇଜର ପାଖରୁ
but prior to marriage
ପ୍ରାୟର ଟୁ ମ୍ୟାରେଜ
yes
ସୋ ୟୁ ହାଭ ଅର୍ନିଂ କାପାସିଟି ତ ସେଇ ହିସାବରେ 6,000 ଦେଇଛନ୍ତି
that may be reduced some reduce
କୁହନ୍ତୁ 4,000 ଲେଖାଏଁ କରିଦିଅ ଦେଇଦିଅ ଆଇ କନସିଡର ଦ୍ୟାଟ୍ ବଟ୍ ପ୍ରୋବ୍ଲେମ କଣ ହବ କି ସେ ଥରେ ଆପଣଙ୍କର ମ୍ୟାଟର ଆର୍ଜନ ହେଲେ ଇଟ୍ ୱିଲ୍ ବି ଏ ଫିସିଂ ଏକ୍ସପେଡିସନ ଆଉ ସେ କେସ୍ ଆସିବନି ଆପଣଙ୍କୁ ସେ ଆପଣ ତାଙ୍କୁ କୁହନ୍ତୁ ଯେ କୋର୍ଟ ରାଜି ହଉନାହାନ୍ତି
sir
ସେ କେତେ ଦେବେ ଆଫିଡେଭିଟ୍ ଦିଅନ୍ତୁ
sir
that will help your client
yes ma'am.
because otherwise you will not listen to you He's not listening. He will not listen to it.
But mediation would be,
Mediation रे आया पैसा किए तब mediation ने पैसा provision नहीं mediation कोठी होगा अपन का restrict section 9 section 13
yes, ma'am.
पैसा दबा ना वाले mediation केम तेम कर परिमी
Well, the husband ready to keep her, man.
ସେଇଟା ଆମେ 9 dismiss ହେଇଛି ସେଟା challenge
sir.
କରିବେ
Yes, ma'am.
ପଢିବେ ଆଜ୍ଞା ସବୁ
Yes, ma'am. 9:30.
ପଢିକି ଇଆଡୁ ସିଆଡୁ କହୁଛନ୍ତି
Again,
section 9 ଆପଣ ଫାଇଲ କରିଥିଲେ
yes, ma'am.
dismiss ହେଇଯାଇଛି ଆଉ ରଖିବେ ବୋଲି ମୁଁ ଏଠି ଗଲେ ମୁଁ କଣ କରିବି ଏଟା ପଞ୍ଚାୟତ ନୁହଁ let us not make it a panchayat conversation ठीक है फिर से ମୁଁ section 9 dismiss ହେଇଛି ବୋଲି ମୁଁ ଜାଣି ନଥିଲି ଆପଣ ଯେତେବେଳେ କହିଲି ପଢିଲେ so I could find that
I filed the
so whatever ଆପଣ affidavit ନିଅନ୍ତୁ the petitioner husband kindly take your seat. I'll just dictate. I'll take some time.
Yes, I'll take instruction.
Whatever, sir.
Yes.
Whatever I'll record that, please. The petitioner husband in the marriage is before this court challenging the judgment dated 23/3/2026 passed by the learned judge, family court, Jajpur in CP number CRP in CRL dot P dot number 143 of 2025. The said petition was filed by the wife in the marriage under section 144 of ENSS seeking monthly maintenance. Application टा फाइल करथिले monthly maintenance at the rate of rupees 20,000 नहीं 15,000 तो 20 लाख परमानेंट एलिमनी सी भी आवरी बगे परमानेंट एलिमनी को प्रोविजन में फाइल है 125 रे परमानेंट एलिमनी बोले 15,000 monthly maintenance. Though a prayer is also mentioned in the application, in the said application, seeking permanent alimony within court. The application has been favored by the learned judge, family court. However, directing payment of rupees 6,000 per month towards maintenance to the wife. Stop. The learned counsel for the petitioner is apprised of the decisions of the Hon'Ble Apex Court rendered in Tanima Faruqi versus Sahid Khan, wherein the scope of interference of this court in exercising divisional jurisdiction in orders passed by the learned family court under section 125 CRPC has been authoritatively dealt with at paragraph 19 and 20. Stop. The learned counsel is also apprised of the decision of the Hon'Ble Apex Court in Rajneesh versus Neha, wherein the scope and applicability of section 125 CRPC has also been extensively dealt with, and guidelines have been issued exercising jurisdiction under Article 141 and 142 of the Constitution of India. Stop. The learned counsel for the petitioner has adjournment to obtain instruction and file affidavit on behalf of the petitioner indicating the amount that would be deposited for securing the award of monthly maintenance due from the date of
the filing of the case.
From the date of filing of the application, that is 4/8/2025. Till date. Next up, the amount comes to 4/8/4 8 months comes to around 48,000. Last period. That's it. I think. No, October. चार ही में पड़ेगा. After vacation, Mr.
এই মাসের sir.
The notice will be listed for fresh submission in the week commencing 18/5.
Yes.
Yes, next.
Item 6.
You have this route, this Shwetapatma route for the petitioner. Yes, please.
Well, I am seeking direction from the Hon'Ble Court to transfer of CP case from the Learned Court Kendrapada to Learned Court Jagatsinghpur. That after my dispute, I am residing with my parents at Jagatsinghpur. Now I am.
What is the application you are seeking for transfer?
Yes,
Is section 9.
Yes, madam.
So what is your objective? Your client's objective? Did you ask her?
Yes, madam.
So what is your objective? She wants to resume matrimony.
Yes, madam. She continued the case at Jagatsinghpur Family Court.
No, you are not answering the question. The family court Kendrapada application is filed under section 9. Suppose now it is transferred to say Jagatsinghpur. So what would be your stand at Jagatsinghpur or Kendrapada or at Cuttack? That is immaterial where the case is pending. Did you talk in those lines to your client? You must understand these are matrimonial matters involving life of individuals. They are impacted by the litigation. Please appreciate that. So you have to talk to them. They have their perception about the proceeding. They have their perception being because like everyone knows about medicine, prescribe some medicine if some symptoms. Nowadays, law also everyone is prescribing something. But if she is interested, so that was the question to you, that what is her intention? To resume, to continue the matrimony, stay with her husband?
No, let's see, not willing to stay with her husband.
Has she filed any application, any cases against the husband?
No.
No cases yet filed. So why you are so skeptical about her staying with the husband? Did you talk to her in those lines?
Her husband
Because
filed the
this
case.
is not a case where you act as a a lawyer also actually. Definitely a lawyer. Apart from being a lawyer, you have to have a larger role as a counselor, as a visionary. The person who is distressed. So she must be guided properly. Because suppose now she tells you, because you say that she doesn't want, but suppose she tells you that I want to stay with my husband. Then your simple approach would to counsel her that then she should tell that before the trial court in the counseling. So that you must understand family court act mandates counseling. Whereas High Court does not have such provision. Professional counseling is available with the family court. They are appointed. There is a specific act and rule. That facility is not available in High Court. And it's a mandate of the statute there. So in the whole process, the litigation is dragged. Ultimately, she will appear at Jagatsinghpur and defend the case. Right? So earliest, if she is agreeable for resumption of the matrimony, earliest she should be advised that you tell the court that yes, I want to resumption of matrimony. Let us go for mediation. I'm sorry, counseling. But if you are not sure or if you want to take instruction, that's a different thing. So by simply filing a transfer petition to stall a proceeding does not help your plan. That is the sum and substance I want to highlight. You have to have that responsibility of taking care of her welfare and what is in the best interest of the person. That way you can put it. Usual legal strategy this transfer jurisdiction is usually now being used only to stall a proceeding. Notice file, transfer petition file kale, stay home. That should not be the approach. Section 9 application, when it is notice is issued, the purpose of the court is for counseling because it is statutorily mandated. But now this court will interdict. So obviously everything will be stalled.
My lord, counseling ta Jagatsinghpur court case se be
Jagatsinghpur re kon adhika haba?
nahi,
Can you say that Jagatsinghpur re better counseling and Kendrapada re less? And if you look at CPC or the Family Court Act or Hindu Marriage Act, there is no prioritization of the wife's choice. There is no. So that is how you will find in none of the petition any reference is made to any statute. Even case law is not very clear on that.
it says now.
ଆପଣଙ୍କର କେନ୍ଦ୍ରାପଡ଼ାରେ କାଉନସିଲିଂ ଖରାପ, ଜଗତସିଂହପୁରରେ ଭଲ, କଟକରେ ବେଷ୍ଟ. Please appreciate those kind of orders this court should not pass.
My lord, jo puri
ଆପଣଙ୍କର ଯୋଉ ଅସୁବିଧାଟା ହଉଛି ଆପଣ ରହିଛନ୍ତି ଏକ୍ସଚେଞ୍ଜ ଦେଇକି ରହିଛନ୍ତି ଜଗତସିଂହପୁରରେ, ultimately ଆପଣଙ୍କର ଯଦି ମ୍ୟାଟ୍ରିମୋନିଆଲ ହୋମକୁ ଆପଣ ଯିବେ, that is at କେନ୍ଦ୍ରାପଡ଼ା. You see what you are saying. You are arguing the contrary to what your objective as you are saying, that you want for counseling and go to resume the matrimony. Take notice.
my lord, say
So that is how instead of issuing notice, I am trying to explain you this, that this strategy of coming to court only to interdict the proceeding does not help the party. Because she can't avail counseling there. Jagatsinghpur counseling ର ହବ ଏବଂ କେନ୍ଦ୍ରାପଡ଼ା counseling ର ହବନି ସେମିତି କିଛି ନାହିଁ. All courts are equal.
ତାଙ୍କୁ distance ଟା problem.
Distance is not a distance ନାହିଁ provision. Nearest to the house of the party, court CPC ରେ ନାହିଁ, Family Court Act ରେ ନାହିଁ, Hindu Marriage Act ରେ ନାହିଁ. କାହିଁକି ନାହିଁ? କାହିଁକି ନାହିଁ? The judge, we have to interpret the law. Rather, it says something else. Section 9 of CPC, any suit to be tried by court. And also it is not there that wherever the wife wants, it should be there. Suppose distance ତାଙ୍କ ଘରଠୁ ହେଇପାରେ, ସେ ଚାକିରି କରୁଛନ୍ତି, ସେ example ପୁରୀରେ କାମ କରୁଛନ୍ତି, ସେ ପୁରୀରେ ବି ଚାହିଁବେ. Please appreciate that. Why it is not there? Because that becomes too much uncertain. Individual choices to the litigation habo, that leads to nowhere. तांका transfer ହେଇଯିବ ତାପରେ ଫୁଲବାଣୀ. Those kind of arguments are being made.
Matrimonial house ଟା ଜଗତସିଂହପୁର ଅଛି ତ
Matrimonial house ରେ ଆପଣଙ୍କର matrimonial house ନା ଆପଣଙ୍କର maternal house.
maternal house.
Matrimonial house ରେ ତ ଆମର that's what Hindu law is. ମାନେ Hindu way of life, not Hindu law. Matrimonial home is the home for the married lady. Hard law counsel for the petitioner. The petitioner wife in the marriage is before this court seeking transfer of the CP number 328 of 2025 pending before the Learned Family Court Kendrapada to the Court of the Learned Judge Family Court Jagatsinghpur. The application, the CP has been filed under Section 9 of the Hindu Marriage Act by the husband in the marriage seeking restitution of conjugal rights. The marriage between the parties was solemnized on 13/5/2021. It is submitted that after the marriage has gone into rough weather, the petitioner wife is staying with her parents at Jagatsinghpur. She is facing difficulty to attend the matter at Kendrapada. Stop. Issue notice to the opposite party along with this order. Requisites for issuance of notice by speed post with registration and proof of delivery be filed within 5 working days. 5 working days or 7?
5.
5 working days. Returnable date be fixed to 29/6/2024. Matter shall be listed on in the week commencing 6/7/2024. Stop. IA 106 of 2026. Hard noted counsel for the petitioner. She reiterates her submissions as noted above. Issue notice as above. Accept one set of process fee as well as postal requisites. Stop. The returnable date and the next date of listing shall be as directed above. Stop. Para. In the interim, it is directed that upon a prayer being made before the Learned Judge Family Court Kendrapada, the CP number 328 of 2025 shall be adjourned to a date beyond 13/7/2024 as would be convenient to the Learned Court in season of the matter. You have to appear and take a seek for adjournment. Yes.
7. I have filed this petition seeking transfer of CP case number 26 of 2026 from the Honorable Judge Family Court Jharsuguda to Judge Family Court Sambalpur in view of the fact that wife initiated a criminal case here at Sambalpur, which is sub judice before the learned SDGM Sambalpur.
ଆପଣ ଯୋଉଠି ବି କ୍ରିମିନାଲ କେସ୍ କରିବେ ସେଇଟା କୋଉ ପ୍ରୋଭିଜନ ଅନୁସାରେ ଟ୍ରାନ୍ସଫର ହେଇଯିବ କନଫର୍ମେଣ୍ଟ ସିଆରପିସି ଡଜଣ୍ଟ ଗାଇଡ ସିପି
My lord, I have also filed a maintenance case here at before the learned Judge Family Court, Sambalpur.
ଆଉ 498 ଫାଇଲ କରିଛନ୍ତି
Yes, my lord.
ଆଉ ଡିବି କାଇଁ ବାକି ରଖିଲେ ୱାଇଫ ଯୋଉଠି ଚାହିଁବେ ସେଠି କରିବେ ସବୁ ଜାଗା କେସ୍ ସେଠିକି ଯିବ ଏଟା କୋଉ କେସ୍ ଲରେ ଅଛି କୋଉଠି ଅଛି କୋଉ ପ୍ରୋଭିଜନ
No, practically, marriage was solemnized in the year 2012.
ସାର୍ ଆପଣ କ୍ୱେଶ୍ଚିନ୍ କଣ ପ୍ରାକ୍ଟିକାଲି ମ୍ୟାରେଜ ୱାଜ ସଲମନାଇଜଡ ଯୋଉଠି ୱାଇଫ 3ଟା 4ଟା କେସ୍ କରିବେ ସେଠି ସବୁ ଜାଗା କେସ୍ ହବ ବୋଲି କୋଉଠି ଅଛି ସେଟା କୋଉ ପ୍ରୋଭିଜନ ବା କେସ୍ ଲ
There is no such case law.
So don't argue. You must argue law. This is a court of law. Suppose I am impressed with your arguments and I pass that order. That order becomes completely bereft of any substance and law. ଆପଣ 10ଟା କେସ୍ ଫାଇଲ କରିବେ ହଜବେଣ୍ଡଙ୍କ ନାଁରେ ତେଣୁ ସବୁ ଜାଗା କେସ୍ ଯୋଉଠି ଆପଣ 10ଟା କରିବେ ସେଠି ହବ That cannot be a ground, Mr. Mahanti.
My lord, another important ground is the wife having a girl child of 13 years of age and is prosecuting study at
The half-less lady with 13 years of a girl child is filing 3 cases against the husband. Criminal cases, she herself is the witness or not?
Yes, she herself is.
So then, she likes to appear in courts or not? Sir, that is the truth.
That is the truth.
Yes. So she likes to file cases against her husband. She likes to appear in those cases before the court. And when the husband files CP, so it has to be transferred. Which case law, which provision is there to pass such orders? You see, you must understand. I may like your argument, but I have to pass an order legally, sound.
Convenient of the wife.
When she will appear in 498A as the witness or DV case, where the child will stay.
Criminal case is pending here at Sambalpur.
Exactly, sir. Where the child will stay. She will appear at Sambalpur, where the child will stay.
She is now residing at Sambalpur.
You must read the provision of law, sir. Argue law, not in this manner. Which provision says that wherever the 3-4 cases are filed by the wife, or in future it will be filed, every case should be transferred there. Is the law gender specific? That wife should be preferred. Wife's cases where is 498 DV and 125 is pending, there the cases have to be filed. And appearance of the court, you like so much in appearing in court in filing cases. Which provision confers jurisdiction on the court for filing CP? Have you examined that?
My lord.
Which provision confers the territorial jurisdiction for filing a matrimonial case, suit, CP, civil proceeding? Which provision?
7 of Family Court Act. Section 7 of Family Court Act.
How कोठी अछि? CPC रे कोठी अछि?
I cannot remember.
CPC section 5 or section 9. Hindu Marriage Act section 17. Nowhere, none of these 3 statutes prescribe that it should be at the wife's place or where wives file criminal cases. So Surendra Mahanti for the petitioner. Section 9. The wife is before this court seeking transfer of the CP number civil proceeding number 26 of 2026 pending before the Lord Judge Family Court, Jharsuguda. under Section 9 of the Hindu Marriage Act by the husband in the marriage, seeking restitution of conjugal rights. Now, it is submitted by the learned counsel for the petitioner that the wife has filed as many as 3 cases against the husband.
2 cases, my lord.
Domestic violence koile para
Na, domestic violence.
has filed 2 criminal cases. Those are pending before the court of at Sambalpur. That is GR case number 48 of 2024 before the Lord Judge STJM Sambalpur under section 498 capital A of the IPC. She has also filed application petition under section 144 of the BNSS 2023 seeking maintenance. The Lord Council is apprised of the provisions contained in Hindu Marriage Act section 17, Family Courts Act section 7, section 9 of the CP Civil Procedure Code and section 24 of the section 9 and 24 of the Civil Procedure Code. Lord Council has adjournment. And it is submitted by the learned counsel for the petitioner that since all the cases filed by the wife is pending at Sambalpur, the application for restitution of conjugal rights filed by the husband should also be transferred to Sambalpur. Then the learned counsel is apprised of these provisions. Provision would have is 19. In prima facie view of this court, reading of all the provisions indicated above does not lead to a conclusion that the CP has to be transferred to a place where the wife has lost criminal cases. The wife filing criminal cases also shows that she is able to appear before different courts, as he has to substantiate the cases filed by her, filing her pleadings, evidence, etc. Stop. After the Lord Counsel for the petitioner has adjournment to address. After vacation or before vacation?
After vacation.
Sir?
After vacation.
As adjournment, list in the matters shall be listed for fresh admission in the week commencing. On 30th. I require your assistance. What you are saying, the proposition may be correct. But prima facie, there is absolutely nothing. But there may be some case law, some pronouncement.
My lord.
Since I do prepare to certain extent, I have not been able to, get any kind of this in these lines. Upon should examine Korea Katha. You are such an active litigant, why you will decide that whatever case is filed, and interestingly, it is for restitution. It is not a 13 application.
My lord, initially he sent a pleader notice.
I guess is it relevant? Pleader notice dele seta Sambalpur transfer if that is the point.
No, my lord.
I can you tell me something which I can direct, or I can order. Since pleader notice was sent, so I should direct the petition to be at Sambalpur. You make out a case where you have to assist the court.
Oblige, my lord.
Yes, please.
Item 8.
If it may please your lordship.
Yes.
Your lordship.
You are Miss Das.
Yes, your lordship.
Is A Das for you have power here?
Yes, sir.
A Das for the petitioner. Yes, please.
Your lordship, we're praying for transfer of a CP case number 84 of 20 26, Your Lordship.
How many cases you have filed? Because Mr. Mahanti has already argued, so I can't change my
Your
view.
Lordship, we haven't filed. We
You
are
are,
just-
you
Your
are yet to file. Because you are conscious that this question will be asked. So after filing the TRPC, you will start filing 498A,
No.
DV
That we have
07.
filed. Your Lordship, that we have filed. That we have filed and we have lodged an FIR, Your Lordship, in Bhubaneswar, FIR number 122 of 2026, Your Lordship. That was dated.
Same thing. I think it is now. So you have also filed.
Yes, Your Lordship.
So what is the proceeding?
Your Lordship, we have filed.
13.
Yes, Your Lordship, 13.
The same question you have to answer.
Your Lordship, actually, Your Lordship, both the parties reside in Bhubaneswar. The opposite party.
So that you see, if you want to defend your case and the court at Hon'Ble lacks jurisdiction, you have to plead there. Already Ganjam and Bhubaneswar have already decided one matter. Suppose you are saying that, if I have understood you correctly, and in fact you are saying that only, that the court at Ganjam is not having jurisdiction, Bhubaneswar is having jurisdiction.
That's not right, Your Lordship, because obviously the marriage.
Because you must understand, did you read the provisions at least before drafting?
Yes, Your Lordship.
So which provision will come to your help after
Lordship,
these section 17 and
Your Lordship, 24 of CPC.
24 kindly read, where it says that wife's choice.
Your Lordship, it's not written.
Then
That's not there in the provision.
yes.
However, Your Lordship, first of all, the petitioner is dependent on her parents, and her father is already.
So if the parents is able to file lost cases, then how she is dependent on parents?
Your Lordship, traveling.
She is filing cases, criminal cases against the husband,
Your Lordship,
being assisted by the parents. So let her defend the case assisted by the parents. A hapless and hopeless. You are saying that she is so hapless and she's dependent on parents, but she is at least filing cases against the husband.
Your Lordship, but her father is.
So you must understand that is there any law on that dependential parents? So it has to be at a particular place.
Your Lordship.
You argue some substance.
Your Lordship, I do have a case law. I don't have the.
Read it. I am going to find and read that it has to be. Now kindly read 24.
General power of transfer and withdrawal on application of any of the parties and after notices to the parties and after hearing such of them as desired to be heard or of its own motion without any notice, the High Court or any district court may at any stage transfer any suit, appeal or other proceedings pending before it for trial or disposal to any court subordinate to it and competent to try or dispose the same, or withdraw any suit, appeal or other proceeding pending in any court subordinate to it.
So why does it say that according to one party choice? Rather it says that after issuing notice to the parties.
To see the convenience of.
Where?
It's not written, Your Lordship.
That's the problem. I'm struggling there. As a student of law, I have a struggle there.
Yes, Lordship.
Because writing is easy because no one can question or maybe challenging. But I must convince myself. This ground of this writing, this convenience of one party. And interestingly, if you now read section 9, when you read 24, you have to read section 9 also.
Courts to try all civil suits unless barred. The courts shall, subject to the provisions herein contained, have jurisdiction to try all suits of civil nature, excepting suits of which their cognizance is either expressly or impliedly barred.
So express or implied bar is the only restriction.
Yes.
In that context, I was telling you that if the court lacks jurisdiction, section 9 will come into play, you can take that plea. Because suppose a wrong place is chosen by the husband, but you are saying that that's not your argument because your answer is something different. Now again check Hindu Marriage Act section, jurisdiction.
Section 19, Your Lordship.
Yes.
Section 19, courts to which petition shall be presented. Every petition under this act shall be presented to the district court within the local.
Anyway, there is no bar of anything, and just look at the plaint Look at the plate, city. Page 8. Badriraj Nagar, fast lane, Gosthani Nuaga, Barampur.
Your Lordship, but he's working at TCS, Your Lordship.
Wherever. TCS will post him in Seattle or say UK. That is not a, you must understand, you must make legally nuanced submissions. Working in TCS is not a will not confer jurisdiction with Bhubaneswar court.
Is Your Lordship, his offices are in Bhubaneswar?
No. You must understand that. Bhubaneswar office does not confer jurisdiction on, assuming Bhubaneswar office. So TCS is headquartered at some other place. Bhubaneswar is one of the offices. So then look at section 7 of Family Courts Act.
Yes, Your Lordship, jurisdiction. Subject to other provisions of this act, a family court shall have and exercise all jurisdiction exercisable.
So there is no such difference. None of the so the question to you is that as a student of law is that none of the acts prohibit there is no express bar. Section 9 says that if there is a bar, that you are saying since you have filed cases against the husband, suppose the husband has filed cases against you at Bhubaneswar, then that can be, because then you can say, arguably you can say that he chooses a place. In one case he has filed against the wife at Bhubaneswar, one case he files at Cuttack, one case he files at Barampur. He has filed only one case. You might have filed 144. I think the section, because I cannot correlate with it is most likely 498A.
Yes, Your Lordship. So that is 85 of BNS, Your Lordship.
85 is equivalent to 498A.
Yes, Your Lordship.
Whatever.
Yeah,
So
yes,
all these. Five 498A, then 296.
Use of obscene language. And then 115 is simple.
So wherever there is a decision regarding this, just examine those cases.
Your Lordship.
Then you come back.
Your Lordship.
And this should not be a strategy for adjourning the matter at Barampur.
No.
Because we are breathing on their neck to dispose of matrimonial causes. Supreme Court is also saying that. 296 is Obscene Act and Songs.
Yes,
294. 351.
Criminal intimidation.
Criminal intimidation. 3-5 hochi bodhe upon dowry provision 4 will location 3-4 3-5.
Yes, sir.
So whenever you are filing these cases against the husband, you are capable enough. And when he files 13 or 9, then you are helpless.
Your Lordship, the problem.
In these cases, will you not appear in court?
Yes,
will you not lead your evidence?
Your Lordship, but the court.
But we just compare. In a criminal trial, you have to, where the standard of proof is very high, you have to appear and get cross-examined, render your evidence in chief.
Yes.
And in civil case, you will do the same thing.
Your Lordship, the problem is Barampur, Your Lordship, is 170 something.
So why is that? Distance is a factor.
Your Lordship.
You may say for ICT,
Your Lordship.
wherever it is possible, ICT can be allowed. But for conciliation, you have to appear physically.
Yes,
How this court will say that the Bhubaneswar is the best place for conciliation or taking up, because otherwise also what you are saying is partly incorrect. Bhubaneswar is overburdened even after having 2 family courts. This will be a case of 2026 May. Suppose it is. Let us assume that your prayer is allowed. So Bhubaneswar is dealing say lakhs of or thousands of cases, tens of thousands. Barampur is dealing some few thousands of cases. No court is less burden. But because nowadays the maximum cases are filed in Bhubaneswar and Cuttack, Bhubaneswar there are now 2 family courts. So we examine in that aspect. You have to assist the court.
Your Lordship, then.
Because my Because I will say that convenient distance. Where are those factors to be considered taken into in which provision? Because 9 is very emphatic. 9 is emphatic and 24 is say that after issuing notice to both the parties. Then why the other parties to be heard? Please appreciate. 24 application by any of the parties, but after issuing notice to both the parties. Why? Because it is your convenience to be looked into. For looking into convenience of the wife, do I need to ask the husband or anyone else? Need not. Examine these aspects.
Your Lordship, if with respect to that, if the provisions are silent, Your Lordship, then case laws may be
Correct. That has been my endeavor. I wish I get assistance to that extent. Any case law is there on this.
Your Lordship, I don't have the copyright.
Please no, examine it. Because what I find, one of your lauded sisters cited one. When I said that, no, she said, then I have not read. Then I said, you please read.
Your Lordship, it's
But then there is only one line. Convenience of the wife. Convenience of the wife, there is no mention in the statute.
yes, Your Lordship.
So you examine it.
Your Lordship, Your Lordship, I can get it now, Your Lordship.
ଆପଣ ଯଦି ଗୋଟେ ଦେଖିବେ ଫାଇନାଲ ଆର୍ଗ୍ୟୁ କରି I may reject that. Because I don't have a power to look at convenience of the parties.
Yes, Your Lordship.
That is the problem. Sorry. Convenience of one party.
One party, yes.
I said the reverse. I have a power to look at convenience of the parties in 24. 9, 17 and even other act also. All acts are very specific that all courts have power. And what about right to equality? I asked you that specifically. Is it a gender specific that
No, Your Lordship.
for the lady will decide the place?
No.
Can be.
Can
Possibly
be.
can be.
Since she's the respondent.
Article 15 is there. Can be, but that's not the law yet.
Yes, sir.
ଏବେ ଆଣିପାରିବେ
The case?
examine କରନ୍ତୁ, you address on this.
Case, Your Lordship, I can get after lunch as well.
After lunch ରଖନ୍ତୁନି, ଆଉ ଗୋଟେ ଦିନ କର.
Your Lordship, any date, short date would be.
ଦେଖ, so actually now you have realized the only strategy is to stall the proceeding at Barampur.
No, Your Lordship, that's not the.
No, that's the legal strategy. This TRP 24 is only the purpose is that for to transfer and stalling. जो दिन notice आसला ता पर दिन file करिवे High Court रे appear करिवे. The effort, the mandate of statutory mandate of conciliation, duty on the court to conciliate, duty on the court to counsel is frustrated by that only. ଆପଣଙ୍କର that doesn't help the person. Because perhaps everyone is not a student of law. जी तांको advice करछन सेठी काहे कि आपण जिबे एठी करिवे. Bhubaneswar counseling is better, but Barampur counseling is खराब सेठी किछि नाही. Everywhere the professional counsel is recruited by the High Court and is appointed. And interestingly, High Court doesn't have that. Suppose I'm entertaining an appeal in Hindu Marriage Act or Family Court Act. There is no scope for conciliation. I'm sorry, counseling. मैं mediation में पठाऊँ. But court in is court monitored, what you call counseling under the Family Court Act is much better. Same order for them. The learned counsel for the petitioner is heard at length. She has addressed on several aspects, supporting the prayer for the input. Oh, the Ketan one item. Appearance act. So when did you, Ms. Das, when did you complete your law?
Your Lordship, I completed in 2023.
Keep it up. The way you are approaching cases is good. May not be that the court is agreeing with you every time, but at least you are perceptive. You are thinking, because I think you have read all the whatever sections I was discussing with Mr. Mahanti. You have read all. That should be the approach. that helps that actually directly improves the quality of the court also. The deliberations we are having, instead of saying one line that convenience of the women should be looked at, transferred. That can be possible. But suppose we discuss all those provisions and everything, so that becomes a precedent for everyone because it's a constitutional code.
Yes.
The petitioner wife in the marriage is before this court. Kindly take your seat and just dictate this. Petitioner wife in the marriage is before this court seeking transfer of CP number 84 of 2026. Pending before the learned judge family court at Ganjar. To the learned, to the court of learned judge family court for that Bhubaneswar.
Yes, Your Lordship.
Yes, I'm just Bhubaneswar. To the court. That Bhubaneswar is खाली Bhubaneswar. Other court that Bhubaneswar. Check court. For that Bhubaneswar. The learned counsel for the petitioner is had some length. She has delved into the provisions contained in the Marriage Act, Family Courts Act, CPC. तापर जोड़ा से संबलपुर जो पैराग्राफ है क्या है? आपको नहीं चाहिए, सीधा डिलीट कर दे, मॉडिफाई हो उनको आते। When do you want?
Your Lordship.
केबे चाहूँ चाहती?
Your Lordship, any short.
Week commencing 18/5 है ना केबे चाहूँ?
Your Lordship, even before that would.
11/5.
Yes, Your Lordship.
The matter shall be listed for fresh admission in the week commencing 11/5. Yes. You had family law in your paper?
Yes, Your Lordship.
How many?
We had Hindu Marriage Act and then.
No, 1 semester or 2 semesters? How many semesters you studied?
So 2, but the first one was only Hindu family.
Both compulsory?
Yes, Your Lordship.
Compulsory.
Yes, Your Lordship.
Yes, next.
Item 11. So I'm appealing for the appeal also.
Petitioner Nandi?
I'm for the petitioner, Your Lordship.
Mr. Jajodia?
No, Your Lordship. Gautam Mishra, Your Lordship.
Mr. Gautam Mishra for the petitioner. Mr. Malik, Pritam Kumar Malik for the opposite party. Yes, please. Go on to sir.
Your Lordship, this is against Order 6 Rule 17 petition, allowing Order 6 Rule 17 petition by the family court. Now, Your Lordship, the trial has already started. After the commencement of the trial, the Order 6 Rule 17 petition has been allowed without observing the requirement of due diligence. According to Order 6 Rule 17 proviso, the court has to conclude mandatorily that in spite of due diligence, they could not have raised the amendment, the subject matter of the amendment before the commencement of the trial.
Amendment application, na? Which is
Page
the next
32,
one?
32.
Page 30, dekho to. Which, according to you, what was your argument in objection? Please appreciate what you are arguing is a 227.
Yes.
227 petition.
Yes, sir.
What you are arguing here should have been argued there.
Was different.
My opinion is concerned, it is mine. Untenable, Lordship. Rightly, the trial court has passed the order, Lordship.
No. So what was his objection? Whether you took this objection before the trial court that these pleadings
Lordship, this is
would
the
not
point.
have been allowed, allowed to be later added despite exercise of due diligence.
Lordship, this is a point of law. It can be raised at any point. That is why, Your Lordship, we are raising it here.
Mixed question of fact and law, because you have unwittingly said that the trial court has not taken into read the CPC. It cannot be a question of law. It has to be a mixed question of fact and law. Order 6 Rule 17 is filed for what?
Amendment of pleadings.
What is pleadings?
Plain plus written statement. That is there.
Correct. So as per general rule of pleadings, say Mugha or anything, have you read that question of law is to be included in the pleading?
No, Your Lordship. Question of law.
Question of law should never be pleaded.
Yes,
when
sir.
you are saying that it is amendment of pleadings, then it is absolutely a statement of fact which is pleaded. Now, if you say due diligence, because you say that despite exercise of due diligence, those pleadings could have been made. Sorry, the contrary you were arguing.
Yes.
His argument is that despite exercise of due diligence, I could not have made such.
Yes.
Correct. So that you have to take before the trial court
Lordship,
and show your written statement objection there.
my objection is at page 33. I concede completely before your lordship that I have not taken it, but my only
Read 2 days back decision of 227 scope. To what extent High Court can do?
So I have cited judgment also. I have
No, show it to him. कितने दिन पूरा?
2021 let's say.
है ना?
2021.
2026 May today is so 2026 May 1st. What is the leading decision on this? Order 6 Rule 70.
the event judgment. Who? The event judgment.
They have enlisted. This
Yes.
court has followed.
Yes.
Year 2009 let's say.
LIC. But LIC is a double-edged sword. When you argue LIC, you have to be ensure that first 1 to 9 or 5 you are there and not there in second. Now, suppose after applying LIC, suppose the court has said that yes, it is to be allowed. Madam has argued 3 hours 30 minutes. Order 6 Rule 70.
The only question, your lordship, is whether they should be allowed.
The problem is now, Mr. Misra.
Yes.
If you do not take that plea, the problem is that the battle lines are not drawn. You have to say that in your examination, objection, then they will say something, the court will adjudicate. If you miss the bus, the only way you do. Now the question is, suppose Order 6 Rule 17 is allowed against you, because you do not want, in that sense. But is it that you lose everything in the case?
Definitely not, your lordship.
Definitely. Correct. You have understood it correct. Because you have a better opportunity to confront that to the other side. So it can be a question of, so first you find out what are the इतने plaintiff and written statement amended. Plaintiff amended.
Plaintiff is the petitioner. The 617 petition is at page 30, your lordship.
Only lordship they want to amend lordship. That word lady and another sentence is lordship. Respondent is a psychiatric patient and her disease is incurable stage.
There is a new ground which is being added through the amendment, your lordship. That I may point out.
You should not say.
Simple.
For objecting, you say old ground. Because
old ground
रे कौन थिला देखो?
Cruelty thila, your lordship.
Cruelty थिला.
Again.
So now the problem is, if you do not, the court does not adjudicate unsoundness of mind or insanity as a ground for mental illness. What? I'm sorry, I'm not using that. Maybe. Then which proceeding will court will decide? Mental disorder. Mental disorder, psychopathic disorder. In which proceeding the court will decide that?
Divorce proceedings.
13.
Yes.
That's
13.
the problem.
Yes.
Divorce proceeding.
Lordship, both the things are being sought. They are trying to improve upon the old ground and also introduce.
Not improve. They have to prove it, sir. By terming the wife as a psychiatric, the suffering having mental disorder and psychopathic disorder, they have to prove it. It is their case. Is there any presumption in CP 13?
No.
So it is there. So it is there. It is up to whether now Mr. Malik is thinking that whether he should have filed Order 6 Rule 17, that's a different thing. They should. Now, does the court do not allow you to file your written statement?
That I always allow.
It has to be.
Yes.
Can you not, what you are saying now, just now, can you not say that in your written statement?
Yes, Your Lordship.
Then, so basically nothing is lost. And if you say it's new ground, then it has to be there because it is well within 13 actually. Suppose declaration of a marriage as a void or voidable. It's not 13. That is, I think it is a 12 or something. Declaratory relief. Then you can 12 is void. So somebody now in a 13 application files an amendment application to declare as a void marriage or voidable marriage. Then you can have this plea. Perhaps. So today or another day?
Lordship, another day.
Another day.
Lordship will post it.
But good that you are preparing, both of you. The petitioner, এটা কত নম্বরে?
11.
The petitioner wife in the marriage is before this court, challenging the order passed by the learned judge family court Bhadrak in CP number 149 of 2023. Order that date actually. Order dated 2/2/2026. Learned judge family court Bhadrak in CP number 80. The said order, by the said order, the learned court has allowed the application filed by the petitioner husband before the said court. এটা 13 আপনারা রেস্টিটিউশন কি ফাইল করছেন?
Restitution I have filed, Your Lordship.
I have filed the deed.
করলে কি? Before said from before said before it. It is applicable. Before it, order 6 rule 17, seeking amendment of pleadings in the CP filed by the husband under section 13 of the Hindu Marriage Act. But the learned counsel for the petitioner was heard at some length, particularly in context of Order 6 Rule 17 and Section 13 of the Hindu Marriage Act. The learned counsel for the opposite party, in his brief response, submitted that the order passed by the learned judge family court of justice needs no interference. Stop. Fine. Before vacation, even.
As Your Lordship pleases.
The matter shall be listed for fresh admission in the next date. Keep it.
Lordship, I do not have instruction.
I don't have instruction.
Matter shall be listed upon next day.
As far as
পর্যন্ত 18 তারিখে কাজ আপন বুঝি জানেন না 500 ওভার পেলে বুঝি পারিবে
বুঝে দিই
500 ওভার পেলে লাস্ট টাইম ডেটা লাগবে the matter shall be listed in the week commencing dash for fresh admission. Then we'll think what can be done. Yes.
Well,
my lord, I am submitting.
This last পরে পড়েলে তিনি তার ডেটটা কইলে Yes, 12.
My lord, I am submitting from Noyar Virtual Court, my lord.
Yes.
The petitioner, alleged husband, files a civil proceeding bearing number 179/24 before the trial court, seeking a declaration that the present opposite party, also the opposite party, in the said petition, not to be his wife. In this proceeding, the opposite party files an I petition hearing number IA bar by 25 seeking for interim maintenance. In this context, the petitioner husband come to this honorable court and files an WPC number 28 by 28 2807 by 26. In that order, this honorable court passed order.
Then you want connected writ petition to be tagged?
Yes, my lord.
More jurisdiction ଅଛି ସେଟା ମୋର determination ରେ ଅଛି ସେଟା
My lord କଥା ହେଇଛି କଣ କି ସେ ଆମର ଯେତେବେଳେ ଟାଇମ ଦିଆଯାଇଥିଲା ଯେ ସିମ୍ପଲ ଆଡଜର୍ନମେଣ୍ଟ ପାଇଁ ସେତେବେଳେ ସେ କଣ କଲେ ଇଣ୍ଟରିମ୍ ମେଣ୍ଟେନାନ୍ସ ଅର୍ଡର କରିଦେଲେ ଇଏଟା litigation expenses ଅର୍ଡର କରିଦେଲେ ସେଇଟା କ୍ୟାନସଲ କରିବା ପାଇଁ ହଜୁର
ସାର୍ ଆପଣ ଏଇ ଯୋଉ କେସ ରେ ଏଇ ଯୋଉ ଆପ୍ଲିକେସନ ରେ what you are challenging sir order directing maintenance
ନାଇଁ order challenging the interim order allowing the litigation expenses.
କେମିତି ହବ ଆଜ୍ଞା litigation expenses ର କଣ judicial review କଣ ହେଇପାରିବ କେତେ ଟଙ୍କା litigation expenses
20,000
20,000 କଣ ଆଜ୍ଞା ଆପଣ ତ କେସ୍ କରିବେ ଆଉ ସେ
ଆମେ ତାଙ୍କ ହଜବାଣ୍ଡ ନୁହେଁ ନା ଆମେ ତାଙ୍କ ହଜବାଣ୍ଡ ନୁହଁ ତାପରେ ସେଇ ସମୟରେ
ଆପଣ ହଜବାଣ୍ଡ ନୁହଁ ବୋଲି ଯୋଉଟା କହୁଛନ୍ତି ଆପଣ ପର୍ସନାଲ ନଲେଜ ରେ ଜାଣିଛନ୍ତି ଯେ କୋର୍ଟ ସେଟା ଜାଣିପାରିବେନି ଯୋଉଟା କହୁଛନ୍ତି ଧରନ୍ତୁ ବର୍ତ୍ତମାନ ମୁଁ କହିଲି ସପୋଜ ଆଇ ଏମ୍ ଇମ୍ପ୍ରେସଡ ଆଇ ଏମ୍ ଅଲୱେଜ ଇମ୍ପ୍ରେସଡ ୱିଥ ୟୁର ସବମିଶନସ୍ as Mr. Barik says the petitioner is not the husband ସେଟା ତ ଇଲିଗାଲ ଅର୍ଡର ହବ
ସେଇଟା
ଆପଣ ହଜବାଣ୍ଡ କି ନୁହଁ ସେଟା ଫାଇନାଲ ଜଜମେଣ୍ଟ ପରେ
ଜଣା ପଡିବ
ସେତେବେଳେ ଆପଣ କଷ୍ଟ ମାଗିବେ
ମାଇ ଲର୍ଡ ଆମେ ସେଇଟା ହଁ
ଏଇଟା ପେଣ୍ଡେଣ୍ଟ ଲାଇଟ କଷ୍ଟ
ହଁ ଏଇ ଯୋଉ କଷ୍ଟ
ପ୍ରୁଭ ହେଇଯିବ ଆପଣ କଷ୍ଟ ପାଇଁ କ୍ଲେମ କରିପାରିବେ ଡ୍ୟାମେଜେସ୍ ବି କ୍ଲେମ କରିପାରିବେ
ହଁ ତେଣୁ ମାଇ ଲର୍ଡ
ଆପଣ ଜିତିଗଲା ପରେ ଡ୍ୟାମେଜେସ୍ କ୍ଲେମ କରିବେ କଷ୍ଟ ବି କ୍ଲେମ କରିବେ
ମାଇ ଲର୍ଡ ମୁଁ
ଆପଣ ଆରମ୍ଭରୁ କେମିତି ଏଟା ମୁଁ କେମିତି ଏଟା ହାଉ ଦ କୋର୍ଟ ୱିଲ୍ नो
ନାଇଁ ମାଇ ଲର୍ଡ ମୋର କହିବାର କଥା ହେଲା
ମାନେ ଇଟ୍ସ ଏ ଡେଞ୍ଜରସ୍ ପ୍ଲୟ ଫର ଦ କୋର୍ଟ ଟୁ अराइव दिस वे और दैट वे since I am not the husband I will not pay the litigation cost how the court will decide that
my lord
matter of adjudication sir
my lord kindly listen my lord
clear
my lord order this court this honorable court ଗୋଟେ order ଦେଇଛନ୍ତି ସେ order କୁ ସେ ଭାଉଲେଟ କରିକି ଟ୍ରାଏଲ କୋର୍ଟ order କରି ଦେଇଛନ୍ତି ସେଇ ଗୋଟେ କଥା ବି ମୁଁ ଆସିଛି
ଏମିତି order ଆଜ୍ଞା କେହି no high court will pass a order that litigation cost ଦେଇ ହବନି impossible order this is impossible order sir
ସେଇଟା କହିନାହାନ୍ତି
ଧରନ୍ତୁ ମୋର ମୁଣ୍ଡ ଖରାପ ହେଇଗଲା ମୁଁ ସେଠି ଅର୍ଡର କଲି ସେଟା ସୁପ୍ରିମ କୋର୍ଟ ସେଟା ସେଟ୍ କରିଦେବେ ନନ୍ ଆପ୍ଲିକେସନ ଅଫ ମାଇଣ୍ଡ
ନାଇଁ ସେଇଟା ନୁହଁ
କଷ୍ଟ ଆଜ୍ଞା କଣ ଏଇ ସବୁ ଜିନିଷ କେମିତି ଆଡଜୁଡିକେଟ ହବ
ନାଇଁ ସେଇଟା କଥା ହେଇଛି କି ହଜୁର ଦେଇଥିଲେ ଗୋଟେ ଅର୍ଡର ଯେ ସିମ୍ପଲି ଆଡଜର୍ନମେଣ୍ଟ କରିବ କିଛି କରିବନି କିନ୍ତୁ ସେଇଦିନ ଆମେ
ଲିଟିଗେସନ କଷ୍ଟ ଆପଣ ନିଜେ କହୁଛନ୍ତି ଲିଟିଗେସନ କଷ୍ଟ ଆପଣ ସେଟା କମେଇବା ପାଇଁ ନହେଲେ ଫାଇଲ କରନ୍ତୁ ମୁଁ ବି ଜାଣିନି ଭେଦର କମେଇ ହବ କି ନାହିଁ ଯଦି 20,000 ଆପଣଙ୍କୁ ଅଧିକା ଲାଗୁଛି ଆପଣ କଣ ଏତେ କମ ଫିସ୍ ନଉଛନ୍ତି
ଯେତେବେଳେ ଏଇଟା
ଜାଣିଛି ବହୁତ ଅଧିକା
ଷ୍ଟେ ଅର୍ଡର ଭଳିଆ ଥିଲା ସେଇ ସମୟରେ ସେ ତଳକୋଟ ଅର୍ଡର କରିବା କଥା ନୁହେଁ
ଲିଟିଗେସନ କଷ୍ଟ ଆଜ୍ଞା ଇଣ୍ଟରଫିୟର କରିହବନି
ଯେହେତୁ ସେ ଅର୍ଡର ଷ୍ଟେ ଅର୍ଡର ଭଳିଆ ଥିଲା ସେଇ ସମୟରେ କରିଦେଲେ ତ ସେଇ ଯୋଗୁଁ ସେଟା ହବା କଥା ନୁହେଁ ମାଇ ଲର୍ଡ ଏଠି ଲେଖା ଅର୍ଡର ମୁଁ କାଇଣ୍ଡଲି ପଢି ଦଉଛି ଟିକେ ପରମିଶନ ଦେଲେ
କେମିତି ହବ ଆଜ୍ଞା no court can pass any order stay of litigation cost ଦେଇ ହବନି ବୋଲି
ସେତେବେଳେ ସିମ୍ପଲ ନଥିଲା ସେତେବେଳେ ହଜୁରଙ୍କ ଷ୍ଟେ ଅର୍ଡର ଥିଲା ସେ ସେଇ ସମୟରେ କରିଦେଲେ ଷ୍ଟେ ଅର୍ଡର ପରେ କରିଥାନ୍ତେ ତେଣୁ ଷ୍ଟେ ଅର୍ଡର ଭିତରେ କୌଣସି ଅର୍ଡର ସେ ପାସ୍
ବେଟର ସାର୍ ଆପଣ ଯଦି ଯୋଉଟା ଟେକ୍ନିକାଲି ରେଜ କରୁଛନ୍ତି ପସିବଲି ଆର୍ଗ୍ୟୁ କରିହବ ବଟ୍ ଇଭେନ୍ ଇଫ୍ litigation cost ଆପଣ ତ କେସ୍ କିଏ ଫାଇଲ କଲେ
ପିଟିସନର ହଜବାଣ୍ଡ କରିଛି
ଆପଣ ତ ଫାଇଲ କରିଛନ୍ତି ଆଉ କାହିଁକି ଆଉ ତାହେଲେ ଆପଣଙ୍କ ପିଟିସନ ଟା କୋଉ କଣ ପ୍ରୋଭିଜନ ରେ ଫାଇଲ କରିଛନ୍ତି 9 ରେ ରେଷ୍ଟିଟ୍ୟୁସନ
ଫାଇଲ କରିଛି ଫ୍ୟାମିଲି ଫଟୋ ଆକ୍ଟ ଅନୁସାରେ ଫାଇଲ କରିଛି
କଣ ଆପଣ ଡିକ୍ଲେରେଟିଭ ରିଲିଫ କଣ ଚାହୁଁଛନ୍ତି what is the declaration you want
ଅର୍ଡର ଟାକୁ କ୍ୟାନସଲ କରି ଦିଆଯାଉ
କୋଉ ଅର୍ଡର କ୍ୟାନସଲ ହବ
2 ଆନେକ୍ଟର
ଆରେ ନାଇଁ ଆପଣ ସୁଟ କଥା ପଚାରୁଛି ଆପଣ ରିଟ୍ କଥା କହୁଛନ୍ତି ଆପଣଙ୍କ ସୁଟ ରେ ପ୍ରେୟାର କଣ
ପ୍ରେୟାର ଥିଲା seeking a declaration that the present opposite party also the opposite party in the said petition not to be his wife
ତାହେଲେ ତ ଆପଣ ତ ଦେନ୍ ସାର୍ ଯଦି ଆପଣ ତ ୱାଇଫ ନୁହନ୍ତି ଫାଇଲ କାହିଁ କରୁଛନ୍ତି
ସେ ଆମ ନାଁରେ ମେଣ୍ଟେନାନ୍ସ ଫାଇଲ କରିଛନ୍ତି ତ ସେଇ ଯୋଗେ କରିଛନ୍ତି।
ତେଣୁ ଆପଣ you have yourself created a situation also. You want a declaratory relief to declare the lady not to be your wife.
ସେଟା ବିଚାରପତି
Now you say that she will not be paid the litigation cost because she is not your wife. So both are same, sir. After it is declared, you get everything. Upon compensation, defamation, whatever tort law रे बहुत जिनस पाइबे. tort law बेसी develop होनी अपन इटा करो.
सेटा
litigation cost के सर interfere करियो बने. I don't know whether it can be reduced अपन सीटिया का करना नहीं.
ସେଇ ଅର୍ଡରଟା
बड़ा modification रे फाइल करन तो this is again advice going to that side. 20,000 टका जदि अधिका लागुची अपन फाइल करन तो सेठी कोर्ट कोन करछन्ती तापर वे तो मे बी विल फाइल हियर. litigation cost sir deny करी होबनी.
my lord.
केबे सुट चलछि सर?
suit is pending, my lord.
केबे कोम छे?
24
आ 2 वर्ष रे 20,000 टका कोन अधिका कॉस्ट देइतले?
नहीं कॉस्ट नहीं जे सेटा
तो लॉस है.
जो स्टे ऑर्डर थिला सेई समय से कले ही जुग हम कहू चैलेंज करछु.
ये स्टे हबनी केबे हेले लिटिगेशन कॉस्ट अवॉइड करे. इट कैन नॉट बी स्टेड.
ये स्टे नथिला स्टे
can a court direct suppose higher court say that high court will not entertain 226. That's the original jurisdiction of the court. Proceeding ta apan ko stay hela but litigation cost apan nije ko 24 पेज केस करचंती. She must have appeared several times. और आज क्लोज हो ना आउ दिन गोटे रहइबो.
चल
आउ दिन
my lord.
So the R Bari for the petitioner, the learned counsel, opposite party flag, the learned counsel for the petitioner being present at the virtual court, High Court of Orissa at Noyagarh, addresses arguments. The petitioner husband is before this court, challenging the order dated 2/2/2026 passed by the learned judge family court Noyagarh in IA number 12 of 2025 arising out of CP number 179 of 2024. Stop. Para. The IA was filed by the lady who is the opposite party in the CP. अपन wife को ले अपन रागी जीवे फिर. से सीपीडा कॉपी अछि कि ना सीपीडा फाइल करना.
सीपीडा कॉपी my lord फाइल करो.
खाली आई फाइल करछ.
आईटा फाइल करछ.
Opposite party in the CP 170 CP number सा कोई छोड़. Stop. The CP has been filed by the present petitioner seeking a declaratory relief against the opposite party lady to declare her not to be his wife. During pendency of the CP, the IA 12, the IA has been filed under section 24 of the अपन litigation ना interim maintenance sir कौन मिलेला 20,000
litigation expenses
in the Marriage Act seeking pendant cost litigation cost and the learned judge family court has by order dated 2/2/2026 मेंटेनेंस कोन आपण चैलेंज करू नांती.
मेंटेनेंस चैलेंज करछु.
आउटे रिट रे मेंटेनेंस रिट नंबर को आपण कहउतले ना कोन आपण सर पूछंती जे ए रिट रे आपण चैलेंज करछंती लिटिगेशन कॉस्ट को then what about the maintenance?
My lord, today I am unable to.
अच्छा सिद्ध नहीं देना Next, সেটা seeking change করো তো seeking pendant light maintenance at rupees 30,000 per month and rupees 20,000 as litigation expenses stop. Not problem. তারপরে কোন লিখবো? As litigation expense. তারপরে কি দেখি the IA has been favored by order dated 2/2/2024. That is under challenge directing payment of rupees 20,000 and litigation expenses. So, the Honorable Counsel for the petitioner is heard at length. He has adjournment to answer. Though it is submitted there. So at length, stop. It is submitted that the opposite party before this court as well as before the Lord Judge Family Court is not the wife of the petitioner. Therefore, she is not entitled to receive any litigation expenses. In response, the Learned Counsel is apprised of the fact that the petitioner himself is seeking a declaratory relief regarding the relationship with the opposite party lady, regarding his relationship with the opposite party lady. And in such view of the matter, whether the Lord Judge Family Court would not have granted maintenance. So, the matter is adjourned. Kebe, sir, before vacation or after vacation?
After vacation.
The matter is adjourned to be listed for fresh admission. Kebe, date karo.
We commence on 3.
Listed in the week commencing on 3/6/20.
Pardon to make a mention, my lord. Item 11, lordship. Trial court next date is lordship 14/5, lordship.
14/5.
14.
There. When it will consume to the matter shall be listed to the date consumed
18.
The matter shall be listed in the week commencing on 3/6. Upon a prayer being made before the Lord Family Court, Madrak, the matter shall the CP shall be adjourned to a date beyond 6/7/2026. As would be convenient to the Lord Court season of the matter. Yes.
13.
Maybe the lordship.
Yes. After recess, because now we have just crossed, so to open a brief, it will take some time. After recess, Mr. Ratha.
Most are order tax shoulder.
Yes.
No. যদি নেই জানতে ভালো হতো নাহলে
copy of the IM may be sought, my lord.
কমলা কপি অফ not sir. My document says it is sir. আপনার অফিসে দেখুন দিব
কেবে
not in the file.
মহান্তি কেবে অর্ডার পাই কেবে আসলে হবে Mr. Ratha, E6 for an extra copy, give him কেবে আসলে হবে কোন তারিখে কোন
স্যার যদি কপি নাই স্যার ମୁଁ আଜି ଦେଇଦେବି କପି ତମକୁ
ঠিক আছে কোন দিন আনিବ তাহলে আজ দিয়ে দিন
Let it come after 2 weeks.
ନାଇଁ ଆଜ୍ଞା ମୋ ଦରମା କଥା I am working without salary for the last 2 years.
instruction ନେବେ କି
Yes,
ବହୁତ
sir.
ଭଲ
And that is interim order by this court.
Yes, I'll take. Definitely.
ହଁ ତାହେଲେ 18 week ରେ ଆସିବ ହେଲା for orders ହେଲା ଠିକ ଅଛି that order I will pass Mr.
Sir, can the interim order is there still? Then they don't. I am not insisting for a contempt. That is why
IA number is 2871.
Sir,
IA number.
IA number.
Again.
Just a second. 2871 of 2026.
अच्छा earlier interim order टा केबे करा
earlier interim order टा sir pass ହେଇଛି 1 second sir.
that is on 10th of January 2022.
Achha. Yes. So, Mr. Mahanti,
My
you will get an extra copy. Please obtain instruction. Okay.
Extra copy will serve in the course of it to him. Personally, I will serve.
Yes. No, I mean, you asked your learned junior.
Me means my associate.
Yes. The rest of the matters after recess.
Sir, এটা কেবে করে
18/5 week রে order se আসিbo.
18?
Yes, sir. Wherever anyone, both parties are present and want a date, he will give you, but please don't insist before vacation. That's some difficulty now. Yes.
Filing the wakalatnama in item number 20. That is my
28.
28
এটা ଗୋଟେ କାଗଜ ସାଙ୍ଗରେ ଲେଖିକି ଦିଅ so that ଯେତେବେଳେ କଲ୍ ହବ ତାଙ୍କର ମନେ ରହିଛି
ଆଜ୍ଞା
ଆପଣ ଗୋଟେ ପେପରରେ ଲେଖି ଆପଣ କଣ ମାନେ ଅବଟେନ୍ ଚେଞ୍ଜ ଆପଣ you are appearing at after the other lauded council has given consent.
After consent.
In 28,
In
28 I am for the petitioner in this case.
28 ନା 20 ଅଛି
28
ଆପଣ ବି 28
28 petitioner by
ସେ ଆପଣ ସେ କହିଦେବେ
item 18.
ସେଟା ଗୋଟେ କାଗଜରେ ଲେଖିବେ
I pray adjournment for item 18 man.
sir ଯୋଉଥିରେ both side ଅଛନ୍ତି please take the date. Please take the date. If you agree for a date, but please don't insist before vacation. ଆପଣ ସେଇଟା ତାଙ୍କୁ କୁହନ୍ତୁ ସେ ଦେଖିବେ କରିକି କରିଦେବେ.
The other side is not there.
Yeah. Please, the petition before your lordship challenging the impugned order annexure 1, my lord, passed by the learned judge family court Baleswar, whereas the petition for call for the records from the Director Agriculture and Food Production Odisha is rejected, and also learned family court clarified that document is not relevant in the present case. What happened, my lord? The fact of the case is that husband filed and divorce petition before the family court Baleswar in the ground that of desertion and cruelty. In the meantime, opposite party, present petitioner being the opposite party appeared and filed the counter and find that the desertion and cruelty is not the proper ground. Only the husband already married. During subsistence of the first marriage, he had married again, and due to that, he filed a divorce petition before the family court Baleswar. And from RTI, the opposite present petitioner, the opposite party and the wife seek some documents and obtain that husband is a government servant and he had taken some plea to transfer from one place to another for the medical treatment of his only son Rahul Chand. Wife, the present petitioner, obtained some document through RTI, and at the time of evidence before the family court, husband also admitted that document was filed by him and his signature is there, and he had transfer for the treatment of his only son Rahul Chand, but not admitted that Rahul Chand is not his son. He said that Rahul Chand is my adopted son. But fact is that from RTI, the present petitioner obtained some documents, and that was the document.
Madam, kindly just so you have now completed the IA. So what is the CP? First you state. What is the CP?
Evidence. Evidence is
CP
going
का
on.
evidence available. So suit रे कौन prayer अच्छी कौन पे file?
Suit रे prayer अच्छी for divorce. Husband filed divorce.
For against wife.
Against wife.
Desertion cruelty.
Desertion and cruelty.
ଆପଣ ଚାହୁଁଛନ୍ତି as a wife
As a wife, ଚାହୁଁଛି ମୋର କିଛି documents ଯୋଉଟା ମୁଁ RTI ରେ ମାଗିଛି ଆଉ କିଛି documents ମୋତେ
latest decision ଦେଖନ୍ତୁ 2 ଦିନ ତଳେ ଆସିଛି ସୁପ୍ରିମ କୋର୍ଟ କହିଛନ୍ତି that's not maintainable.
ଆଜ୍ଞା
what the trial court has held, Supreme Court has held the same thing. Desertion cruelty is the allegation, you have to disprove it that much.
That's much.
You must understand that. Suppose it is your petition, that's a different thing. You are the defendant.
Not.
So you file
Yes,
your written statement.
I am the defendant. Husband filed the divorce petition on the ground of desertion cruelty. I obtained some document, but my case is that that was not the proper ground for desertion and cruelty is not the proper ground. As the petitioner before the family court has already
Proper ground, when you are saying proper ground, you are saying as if you are the petitioners. Madam, you are the defendant. So proper or the improper ground, suppose you are saying that no case is made out, that is enough.
No, here I am here that family court re mugote call of the documents magithili.
Why? What for?
RTI re see ame pailu je see he had already married and one of son is there.
So apan pleading re dekhantu.
Pleading re mu dekhaichi.
That is enough.
Pleading re dekhaichi RTI re
WS kind.
WS I had not annexed WS.
Apan dekhibi na. You are a defendant in a suit. You want calling for record in the suit which is filed by the petitioner. Petitioner is the dominus litis. You have to disprove the case of the petitioner that much. Record kon hobo?
Record hobo. Say document ta evidence re asiboni tale to heparibon na amku ame seita se jo RTI re
sete kuha jaeni ei paribon bel jo कहउचंती सेटा आपण कोर्ट से प्लीडिंग नहीं चंती जे आपण एटा सपोर्ट करूचंती को जिंसटा.
Yes, I had tried.
आपण इम्प्यून जजमेंट ता देखंतु. इम्प्यून जजमेंट ता पढो.
Yes. I want to draw your lordship see the impugned judgment page number last page number.
एटा पढिबे ना लास्ट पढिले बुझी परिबे.
Oh, all right.
बुझी परिबे आपण बुझी परिबे मुझी परिबे.
Yes, all right. From 9 I may be permitted to submit my.
Yes, please.
This order arises out of the petition filed by the respondent dated 9/12/2025 with prayer to call for certain documents from the Director Agriculture and Food Production Odisha, Bhubaneswar, on the ground stated therein for hands of justice. It is a case of respondent that she has arrived in this WS about the fact of the second marriage of the petitioner with another lady prior to filing of the case, and that the petitioner is blessed with a boy namely Rahul Chand out of his second marriage. However, the petitioner, while was serving as agricultural engineer on the ground of ill health and treatment of his son, had filed application before this authority, that is Director Agriculture and Food Production of his transport as JO to Agalpur block, Balangir, and he had also enclosed the copies of the medical documents of his son. According to the respondent from the said application, it is clear that the petitioner has got second marriage. That apart, when she came to know about the application of the petitioner, which she had filed before his authority, she obtained the copy of the said application through RTI and has filed in this proceeding. It is further pleaded by the respondent that the petitioner, while being examined as PW1, has also admitted about that application under Exhibit A and his signature thereon. He had also admitted that he has got treated his son Rahul Chand at Sri Satya Sai Institute of Higher Medical Science, Prasanti Gram, AP, in or other hospital. It is sole content of the respondent that the application dated 13/1/2010 and the other medical documents are relevant and material one to prove that second marriage of the petitioner and that he is the biological.
I have completed reading. Let us not spend more time. The order is perfect. It is not against you also.
Yes, my lord.
How do you prove a marriage?
Yes.
How do you prove a marriage?
It's because.
How do you prove a marriage? Not as because. दिजन भितर बाहागर हेले केमती प्रूव करिवे?
Medical certificate is there.
Medical certificate बाहागर प्रूव हे परिबे?
जो marriage certificate is there.
Marriage certificate प्रोड्यूस करिवे?
Produce.
नहले जे बाहागर करिथिबे ताको विटनेस करि डाकिबे?
Witness करि डाकिबे?
जे बाहा होइछन ताको डाकिबे? आपण कागज मागुचंती गोटे एप्लिकेशन छुट्टी एप्लिकेशन
नहीं छुट्टी एप्लिकेशन नहीं से सेठी देइचंती जे मोर पुओ आउ से किछि डॉक्यूमेंट्स
सेना आपण इमेजिन करू
जे टू गवर्नमेंट सर
आपण करो
नो वी हैड ऑब्टेन द RTI वी हैड ऑब्टेन दैट
सो आपण यू प्रोड्यूस दैट you produce that. Apana diye padhontu page 11.
Yes, page 11. Page 11. The respondent in her WS specifically has...
Rahul Chand treatment document application is not enough. ଆପଣ ପଢନ୍ତୁ ଆପଣ ପୁରା ପେଜ 10 ରୁ ପଢନ୍ତୁ ସପାରା ପେଜ 10 ରୁ ସପାରା ପଢନ୍ତୁ
Okay, ma'am. I have heard from High
ଆମର ରିଟିନ୍ ଷ୍ଟେଟମେଣ୍ଟ ରାହୁଲ ଚାନ୍ଦ ପୁଅ ବୋଲି କୋଉଠି ଷ୍ଟାଣ୍ଡ ନେଇଛନ୍ତି କି?
ହଁ
ଯଦି
ଆମେ
ନେଇଛନ୍ତି ତାକୁ କଣ ଆପ୍ଲିକେସନ ରେ ପ୍ରୁଭ କରିବେ? Rahul Chand is father of son of so and so Chand. You have to prove by some other evidence, not by application from his employer. So that
the birth certificate
court has helped you. Court has helped you. Not spoiling your case.
Yes.
I have heard learned counsel for both the parties.
Yes, I have heard the learned counsel for both the parties peruse the record. This is proceeding filed in 13(1) of the Hama Act by the petitioner seeking divorce on the ground of the cruelty and desertion. This is a case for the year 2018, but till date, the cross-examination of the petitioner is yet to be completed.
Let us slowly put ଆପଣ 8 ବର୍ଷ ହେଲା କ୍ରସ୍ ଏକ୍ସାମିନ୍ କରୁନାହାନ୍ତି 2026 ରେ ଆପ୍ଲିକେସନ ଫାଇଲ କରୁଛନ୍ତି ତାଙ୍କ ଛୁଟି ଆପ୍ଲିକେସନ ର କପି you must understand what you are doing ଆପଣଙ୍କୁ ଲାଗୁଛି ଛୁଟି ଆପ୍ଲିକେସନ ଦେଲେ ପ୍ରୁଭ ହେଇଯିବ ଛୁଟି ଆପ୍ଲିକେସନ ରେ କିଛି ପ୍ରୁଭ ହବନି
ଆପ୍ଲିକେସନ ନୁହେଁ ସେ ଯୋଉ କିଛି ଡକ୍ୟୁମେଣ୍ଟ ଦେଇଛନ୍ତି
ଆପଣଙ୍କର ସବୁବେଳେ ସେକେଣ୍ଡାରୀ ଏଭିଡେନ୍ସ ଆଡ୍ୟୁସ କରିବେନି ଆପଣ ଯଦି ଚାହୁଁଛନ୍ତି ଆପଣ କଣ ପ୍ରୁଭ କରିବେ ସେଟା ଆପଣ ତାଙ୍କ ପୁଅ ବୋଲି ରାହୁଲ ଚାନ୍ଦ ଆପଣ ପ୍ରାଇମରୀ ଏଭିଡେନ୍ସ ଦେବେ ପ୍ରାଇମରୀ ଏଭିଡେନ୍ସ କଣ
ବାର୍ଥ ସାର୍ଟିଫିକେଟ
ଆଉ କଣ
ସ୍କୁଲ ସାର୍ଟିଫିକେଟ
ସେଇଟା ଏଇଥିରେ ଆପଣ ଛୁଟି ଆପ୍ଲିକେସନ ର କପି ଚାହୁଁଛନ୍ତି
ଛୁଟି ଆପ୍ଲିକେସନ ସହିତ ତାଙ୍କର
ମ୍ୟାଡାମ ରିଡିକୁଲସ୍ ଏମିତି ଓକିଲ ପଢିଲେ ଲୋକର ଗଲା ଭାଗ୍ୟ ଗଲା ଆପଣ ତାଙ୍କୁ ଆପଣ ହାଇକୋର୍ଟ ରେ ପ୍ରାକ୍ଟିସ କରୁଛନ୍ତି ତାଙ୍କୁ ଗାଇଡ କରୁନାହାନ୍ତି
ଆଜ୍ଞା ମୁଁ କେବଳ ଲାଷ୍ଟ
ଛୁଟି ଆପ୍ଲିକେସନ ରିସେଣ୍ଟ ଡିସିଜନ ଦେଖିଲେ 4 ଦିନ ତଳେ ଆସିଛି ସୁପ୍ରିମ କୋର୍ଟ ର You cannot apply in RT the income of because it is a personal information.
Personal income.
Personal information ଆପଣ ଛୁଟି ଆପ୍ଲିକେସନ ଆପ୍ଲାଏ କରୁଛନ୍ତି
ନାଇଁ ଛୁଟି
ସେ କୋଉଠି ଚାକିରି କଲେ ଆପଣଙ୍କର ପ୍ରାଇମରୀ ଏଭିଡେନ୍ସ ଯଦି ଦବାର ଥିଲା 8 ବର୍ଷ ହେଲା ପାଇଲେନି
ପ୍ରାଇମରୀ
ତାହେଲେ ଛାଡ଼ନ୍ତୁ
ଆଜ୍ଞା ଲାଷ୍ଟ
ଆଉ ଟିକେ ପଢନ୍ତୁ
କିନ୍ତୁ ଲାଷ୍ଟ ଯୋଉ ଲାଇନଟା ଦେଇଛନ୍ତି that is not relevant to me
ଆଜ୍ଞା ଫ୍ୟାମିଲି କୋର୍ଟ ସୁଟ୍ ରେ ଆପଣଙ୍କର ଆପଣ କ୍ରସ୍ ଏକ୍ସାମିନ୍ ସାରିବେ ସିଏ ତାପରେ ତାଙ୍କର ଏକ୍ସାମିନେସନ ଚିଫ ହବ ତାପରେ ଯାହା ହବ ସେତେବେଳେ ଫ୍ୟାମିଲି କୋର୍ଟ କିଛି ଡିସାଇଡ କରିନାହାନ୍ତି ଆପଣ ପଢନ୍ତୁ
but last line is maybe hardship for me last line
This case is for 18, but still the cross-examination of the petitioner is yet to be completed.
Yes, but till date the cross-examination of the petitioner is to be completed. The respondent
needs to complete.
Aye.
You have to complete.
Yes.
ଆପଣ cross examination ରେ ଆପଣ ପଚାରିବେ ତାଙ୍କୁ
ଆଜ୍ଞା
ତାହେଲେ ଆପଣ କରୁଛନ୍ତି କଣ ଆପଣ ତ RTI ଫାଇଲ କଲେଣି ତାଙ୍କୁ ଆପଣ ତାପରେ ପଢନ୍ତୁ
କ୍ରସ୍ ଏକ୍ସାମିନ ପାଖାପାଖି ଅଧା ହେଇଗଲାଣି ଲାଷ୍ଟ
8 ବର୍ଷର ଅଧା ହବ ଆଜ୍ଞା
ସେ ପ୍ରେଜେଣ୍ଟ ଆସୁନାହାନ୍ତି କାଉନସିଲିଂ ହଉଛି
ସେମିତି ହୁଏନି ଆଜ୍ଞା କାଉନସିଲିଂ କଣ ହବ
ଆଜ୍ଞା
but court is too lenient actually.
Again, the respondent in her WS has taken the plea about the second marriage of the petitioner and son, namely Rahul Chand, is born during the said second marriage. The sole content of the respondent that
contention.
Sole content of the respondent.
Contention, yeah, content alga, contention alga.
Contention. Yes, I bow down. The sole contention of the respondent that the petitioner had filed the application on dated 13/1/2010 before his authority for his transfer of the AJJO Agalpur block Balangir on the ground for treatment of his son Rahul Chand. It is further transfer is from the case record that during course of cross examination the petitioner has admitted the said application dated 13/1/2010 and its contents under Exhibit A. At this juncture, the respondent filed the present application with a prayer to call for the said application along with other 12 number of documents relating to the treatment of said Rahul Chand to prove the second marriage of the petitioner. Pertinent to mention here that the respondent has specifically arrived in her WS para number 21B that knowing about the treatment of Rahul Chand by the petitioner, she has obtained information from the authority of the petitioner. So RTI Act and from the said document, she came to know that Rahul Chand is the son of the petitioner through second marriage and the birth of child took place much prior of filing of this case. It reveals from the cross-examination of PW1 at para 4 that he has specifically denied about his second marriage and birth of the son, namely Rahul Chand. The respondent in her WS specifically has not stated anything about the documents, but she want to call for from the Director of Agriculture and Food Production Orissa, Bhubaneswar. The fact of the matter is that the respondent has erred in her
Avoid. Not arranged. Avoid in a
Ever in her WS that she had already obtained information from the authority of the petitioner under the RTI Act, from which she came to know that Rahul Chand is the son of the petitioner. So when the respondent has documents with her obtained under the RTI Act, she is at liberty to produce and prove the same at the time of her evidence, and as such, there is no necessity to call for the same documents from the authority of the petitioner. That apart the documents sought to be called for are no relevant to the present case to decide the issue. Only
that
this line
is important. The reason being,
yes.
आपण गोटे बात प्रूव करिया पे मैरिज प्रूव करिया पे छुट्टी एप्लीकेशन अप्लाई करछन
आज्ञा ना आउ बहुत
माने नॉट इवन सेकेंडरी तापर माने आपण टर्शियरी एविडेंस को भी जाउ ना आपण जदी बात प्रूव करिया कथा आपण का आपण मटेरियल विटनेस को प्रोड्यूस करिवे मैरिज सर्टिफिकेट विच प्रोड्यूस करिवे कि बात सर्टिफिकेट प्रोड्यूस करिवे आपण गोटे एप्लीकेशन ने से लिखले सो लेट अस अस्यूम आपण जोटा कहउछथि जे से Rahul Chand is my son. Say, like the application they chandi. Does it prove the marriage with the first lady?
That is not.
So please, the court has helped you.
That line, this line, only this line may create hindrance.
That is the best line in the judgment.
This
The
line
is the only best line in the judgment. Actually, the court should not have discussed all these things. By applying a RTA application of a leave application before the authority, how do you prove somebody's marriage?
Oh, yes.
You are not going for the primary evidence.
Primary evidence is
Evidence Act रे आपणकर evidence कौन अछि?
primary evidence is not with me in this matter.
With you, अरे आप not with you, but primary evidence of a marriage कौन हवा? आपनको evidence तो तीनटा character, तीनटा feature, relevancy, admissibility and weight. आपण जोटा evidence adduce करे पे चाहिए, that's not even relevant. Must understand कि ये सब idea दोची 8 वर्ष वाला suit चलची, आपण prove करचंती adultery allege करचंती. Adultery जदि allege कले आपण adulterers को आपण पार्टी करिवे सब जिनस एडवाइस कोन मु देबी एज अ लॉयर कोन आपण करिवे सेटा बट कोर्ट हैज सेव्ड यू
but
आपण कर सपोज even assuming that this is allowed you produce that application
yes
your opponent counsel will take 1 minute to demolish your entire case how does it prove anything आपण कोन application कोडी के देला and that is in the realm of service.
Many documents are there, only not only that application. Not only that application, many documents
so I am not inclined to interfere. Hela. समस्त adjournment is adjournment नेबे ना आज सर जीवो please.
Adjournment no to let me discuss with them to the court below.
Discuss आप कौन करियो? But I will not pass the order. The petitioner wife in the marriage is before this court. I had learned counsel for the petitioner at length. The petitioner wife is before this court challenging the order passed by the learned judge family court. Balasur. In an application rejecting prayer of the present petitioner wife. Take yours. Just take yours. Prayer of the present petitioner wife calling for certain documents from the employer of the petitioner before petitioner dash husband, the employer of the husband dash petitioner before the learned judge family court in CP number 110 of 2018. The CP number 110 of 2018 has been filed by the husband seeking grant of decree of divorce and dissolution of marriage under section 13 of the Hindu Marriage Act. The application filed before the learned trial courts calling for the records is annexed to the writ application marked as Annexure 4. which discloses the document sought for is regarding treatment of one Rahul Chan, who the petitioner hearing from opposite party before the Lord's trial court says to be the son of the petitioner, son of the husband. So, having gone through the order passed by the Lord Judge Family Court, apparently the Lord Court has dealt with the petition in its proper perspective. Having gone through the order dated 25/3/2026 passed by the Lord Judge Family Court. Dealt with the facts and the question of law involved in its proper perspective, which requires no interference. The Lord Counsel for the petitioner seeks and has adjournment. The Purvur add kar debe. The documents sought for are no way relevant for proving the allegation of the wife, who is the defendant, that the petitioner has married. Marriage the second marriage na same marriage the first.
First marriage.
The petitioner has married during subsistence of her marriage with him. So, for proving marriage during subsistence of the first marriage, the defendant has to adduce primary evidence for proving factum of marriage, not by alleging that the husband's, not by alleging that that husband has a child out of the second marriage. Stop. From another perspective, whether child is born out of the marriage, Indian code, civil code, is not relevant to prove the second marriage during subsistence of the first marriage. एक केस गुड़ा पकेकी रखंतुनी तापर आउट लिखंतु the London trial court is correct in observing that the matter is kept pending for the last 8 years and the defendant and slow down to overlapping, and the defendant is yet to complete the cross examination of the petitioner. Defendant wife is yet to complete the cross examination of the petitioner husband. आपण से लेडी को ना लिखिଛନ୍ତି?
No.
केमती प्रूफ करियो?
Exactly.
25A देखो. You have to take that plea as a in the section Hindu Marriage Act application. आपणकर डिफेंस होची you have deserted because of cruelty.
Yes.
Because of his cruelty, you have deserted.
No, we had not deserted. Husband filed the divorce petition and he alleged that deserted is there.
When desertion is alleged against the party to a marriage, the usual defense is the cruelty by the other side. So he or she cannot take advantage of his own wrong. That is the usual plea. So, आपण सेटा भाबिबे ना. आपण जेतिकी रिटन स्टेटमेंट अछि ताको सेटी प्रूफ करो. केबे आसीओ. Now the Lord Counsel for the petitioner seeks adjournment. Seeks and has adjournment. The matter shall be listed for fresh admission in the week commencing. After vacation.
After vacation any day.
Any day तो नौनी computer कौन करिया?
We come to 29.
29.
Always.
14th.
Mr.
In the meantime, if I file the adjournment petition before the court will. I is there.
No.
Till 29.
Nothing, sir. Nothing, madam. You must understand that you are treating the High Court to be a party to the whole process of 8 years of a suit being kept pending. Your endeavor not to face the trial, to expedite the trial, you are making the High Court a party now.
Yes.
Cannot be.
May please.
Mr. Rajiv Kumar Mahanto for the petitioner. Mr. Prem Kumar Mahanti for the opposite party. Yes, Mr. Mahanta.
Petitioner challenging the cancellation of PDS license by the authority which has been affirmed by the appellate authority, my lord.
Upon appeal order challenge kurchun.
My lord.
Take notice.
My lord.
Yes, Mr. Mahanti. Hard lauded counsel for the petitioner. The petitioner in the writ application is before this court. Challenging the order dated 25/2/2026 passed by the ATM na collector.
Collector.
Passed by the opposite party number 2. Number 2 authority in PDS public list PDS appeal number 01 of 2026 under the provisions of PDS control order 2016. Under order 14 of appeal ta ko provision
19.
under order 19 of the
Odisha Public Distribution System Control Order 2016.
The order 19 of the Odisha PDS control public distribution system into packet control order 2016. Also under challenge is the order passed by the sub-collector and licensing authority dated 26/12/2025 suspending the PDS license of the petitioner. Stop. What are the grounds of challenge, Mr. Mahanta? No grounds is the best ground, or what?
Paragraph 19.
Paragraph 19 now can be. Grounds to that one to make your submission.
My lord, authorities failed to appreciate that some of the witnesses stated that they are getting PDS stop regularly, my lord. Those are filed complaint against the petitioner, my lord. They are not the beneficiary under the petitioner.
Submitted that both the orders by the sub-collector as well as the appellate authority suffers from manifest illegality and lack of proper appreciation of material on record and evidence, inasmuch as the persons who have deposed regarding non-supply of PDS commodity are not the beneficiaries under the petitioner. It is further submitted that some of the beneficiary witnesses say upon witness na upon witness.
During process of inquiry, some of
the witnesses during inquiry process have also stated that they are getting the PDS commodities regularly without any difficulty. Stop. You should notice along with this order.
I have a submission, ma'am. There is a provision of review, ma'am. I think according to
ପରେ ଦେବେ ଆପଣ କଣ ରିଭ୍ୟୁ କରିପାରିବେ ସେ ଯୋଉ ପାୱାର ପଳେଇଲାଣି ଆପଣଙ୍କର ତଥାପି ଆପଣ PDS ତ ଭଲ ଅର୍ଡର କରୁଛନ୍ତି 2 orders I have seen ଗୋଟେ ଅର୍ଡର ତ ଆପଣ ରେଷ୍ଟୋର କରିଦେଲେ ବିକଜ ଆଉ ଗୋଟେ ଯୋଉ ଗରିବ ଲୋକ ସେ ତା କହିଲେ ଯେ ପ୍ରପର ଇନକ୍ୱାରି ହଉ ସେଟା ସେ ଲୋକଟା ଗରିବ ଲୋକଟା ନା କଣ ସେ ତାର ନଥିଲା ଆଉ ଗୋଟେ ଲୋକ କହିଲେ ଆପଣ ପ୍ରପର ଇନକ୍ୱାରି କରନ୍ତୁ ଇନକ୍ୱାରି କରିକି ଫ୍ୟାକ୍ଟ ଫାଇଣ୍ଡିଂ ଅଥର ଦେଇକି ତାପରେ ଦିଅନ୍ତୁ ୟୁ ଆର୍ ଡୁଇଂ ଗୁଡ୍ ଜବ୍ ଆପଣ ରିଭ୍ୟୁ ଆକ୍ସେପ୍ଟ କରିବେ ତାଙ୍କ କଣ୍ଟେକ୍ଟ କଣ କହୁଛନ୍ତି
ନା ମୁଁ ଏଇଥିରେ
along with this order, the Lord Additional Standing Counsel upon advance copy served appears and bears notice on behalf of the opposite parties 1 to 6. It is submitted by the Additional Standing Counsel that there is a provision for review of the order passed by the appellate authority.
Yes.
Who provision na kayo?
20.
Again? Sorry.
20.
Under order 20 of the
20.
of the PDS control order 2016. Stop. For the time being, keeping the said question open, keeping the said question open. The learned the additional study council shall obtain instruction and file counter in response to the writ petition. Upon serving copy thereof for the learned counsel for the petitioner, stop. The petitioner shall have liberty to file rejoinder in response to the counsel. The matter shall be listed for admission in the week commencing 13/7/2024.
IRA with notice.
IRA for November final order IA 76392026. What IRA कौन ही करेगा इसको?
Stay मांगी थी से इसको.
Stay ही करेगा. ऐसा तो मुझे अलग कर दियो. आज ही अलग हुई जो. IA लाई होगा ना. IA 76392026 से लाएगा.
15.
The PK Satapathy for the petitioner, Mr. PK Mohanty for the AC for the opposite party state. Yes, Mr. Satapathy.
The petitioner's license has been suspended by the licensing authority, which was confirmed by the appellate authority under Annex 1. Both the order is challenged. The allegation against the petitioner about discrepancy in shortage of 2 quintal rice and other allegations, formal allegation, the display has not been mentioned properly in the board of the sub little point, and the record has not been produced to me.
Formal, serious allegation. ଆପଣ କହୁଛନ୍ତି ସେଟା କେହି କରନ୍ତି but the rule is
that is the statutory. I have
record has to be maintained and display has to be there.
In response to such allegation, I have made some reply that has not been taken note by the.
से लिखा है कि objection से जो display.
हाँ से कला सिलेट रे लिखा है तक किरोसिन चीनी.
किरोसिन पूरा लिखा है नहीं.
नहीं इसी तो लिखा है बड़ों की.
K oil
लिखा है
तो लिखा है तो.
That is the.
से अपन जिबे सब मासे जो समान
figure थे.
तो सेटा अपन कभी जैसे formal, that's not formal, that is serious allegation. Anyway. So
inquiry has been conducted by the licensing authority. We have made reply. My reply has not been taken into consideration. The report has been of the license inspector has been accepted. That has been treated as a gospel truth, since there is some irrelevant question points has been entered into the premises regarding the misuse of power of an inspector, and there is some unnecessary, unusual things.
Upon the Rogedere, Inspector, Mr. Mohanty now is taking up the other PK is taking a review. Upon review, read. Same order.
Same order, only suspension. In last order, that is your case of cancellation. My case is suspension.
I think that is a suspension also. The petitioner is a public distribution system dealer, regulated by the provisions of Orissa PDS control orders. This is a public distribution system into packet control order, 2016. Before this court, the petitioner challenges the order dated 30.01.2026, passed in a PDS appeal number 03/2025 by the collector Balasur. Under the provisions of Order 19 of the PDS Control Order 2016, by the said order in appeal, the collector has confirmed the order passed by the sub-collector DASCOM, licensing authority, dated 18/10/24. Dated 22/8/24, passed in PDS miss case number 27/20/24. 16 na kecheda 16 violation of ये सब कलेक्टर में कौन ऑर्डर होगा
सब violation of clause 10(1)(m), clause 10(2)(c)(d). Page 15.
कौन लिखा? Observing that there has been violation of the mandatory orders such as Order 14, 15, 17. So, High Learned Counsel for the petitioner, para, it is submitted that the decision of the sub-collector is based on irrelevant considerations, as well as failure to take note of the relevant consideration for adjudication of the matter. The collector did not consider the show-cause. The sub-collector did not consider the show-cause of the petitioner dealer, nor did the collector deal with the said aspect in the appeal. Stop. You should notice along with this order, the learned the learned additional standing counsel, Mr. Mahanti, learned additional standing counsel upon advance copy served appears and waves notice on behalf of the opposite parties. Stop. The learned additional standing counsel submits that the petitioner has statutory remedy of review before the appellate authority. Stop. Notice is issued keeping the said question open. Stop. The learned additional standing counsel shall obtain instruction and file counter in response to the amendments made in the writ application. Stop. The matter shall be listed for admission in the week commencing 20/7/2026. You let me counter. Upon serving copy thereof on the learned counsel for the petitioner, stop. The petitioner shall have the liberty to file rejoinder. The matter shall be listed for admission. The week commencing 20/7/2026. Yes.
60.
IA to lie over. Mr. John J.K. Ratha, Senior Counsel, along with Mr. Durgesh Narayan Ratha for the petitioner, Mr. P.K. Mohanty, Additional Standing Counsel for the opposite party. The IA does equal to IA 2871 of 2026. The IA has been filed in the pending writ application with the following prayer. Prayer to court for the learned counsel for the learned additional standing counsel requests for an extra copy of the IA. Stop. Copy of the IA shall be served on the stop. Para. It is submitted by the learned senior counsel that no copy has already been served. He shall ensure service of copy on the learned additional standing counsel to the learned instructing counsel. Stop. The additional standing counsel shall obtain instruction and file his response to the IA by 14 दिन सुधा दे परियो 18 आसो अपन 14 सुधा by 14/5/2026 अपन सर्विंग केयर कॉपी दे होला ठीक है जी 15/5/2026 अपन सर्विंग कॉपी दे रहा फॉर द लर्नेड काउंसिल इंस्ट्रक्टिंग काउंसिल फॉर द petitioner list in the week commencing 18/5/2026. Yes. Next.
17.
Delay. 17 के मेंशन करना है petitioner non appears for the petitioner when the matter is called. The matter was earlier the matter was earlier dealt with at some detail. In some detail, not with, in some detail, as reflected in order dated 15/4/2026. Stop. The order dated 15/4/2026 is reproduced here. On 30/3, prior to that, on 30/3/2026, none had appeared for the petitioner and the following order was passed. Stop. Apparently, the petitioner is not for prosecuting the matter and it is kept pending for last about 4 years. Stop. The matter shall be listed in the week commencing 18/5/2026, indicating that the matter will be disposed of listed for orders for them be disposed of. Listed for fresh admission, listed for fresh admission in the week commencing 18/5, indicating that the matter shall be disposed of. Copy of this order shall be forwarded to the learned counsel appearing for the petitioner by the registry. Stop. Yes, next.
18.
You are Mr. Mohanty.
Das, man.
Mr. 18. Mr. M.R. Das.
Yes, man.
So M.R. Das for the petitioner. Mr. You wanted adjournment, please?
I was seeking adjournment because I have come up after a prolonged treatment, my lord. I'm not able to speak properly. That's why I was seeking an adjournment.
So you accommodate your friend or he may engage somebody, but must have personal difficulty.
Yes, yes.
So M.R. Das for the petitioner, Mr. A.K. Ota. You have not informed, you were not aware he is present.
Yeah, when I was submitting, he was not there.
So A.K. Ota for the opposite party. The learned counsel for the petitioner opposite party seeks accommodation on ground of personal difficulty. Stop the matter shall be listed after vacation, Mr. Das.
Yes. One submission, madam. The interim maintenance may kindly be.
For instruction, new.
Interim maintenance.
Last few months, they
in
have
the
not
last
paid.
occasion, I have taken instruction. There was an order to attach his savings bank account to wherein he is getting his pension. That has been attached. So he will get regular pension from that, regular maintenance from that.
Since instruction don't ask for what they most likely what Mr. Ota is saying that if the deducted from the pension that is his savings bank account, it will be regular. The learned counsel for the petitioner, Mr. Das submits that the appearance petitioner submits that the petitioner is not getting the monthly maintenance directive. Stop. In response, it is submitted by the learned counsel for the opposite party that the account, savings bank account where the pension of the opposite party is credited has been attached as per the directions of the court, and in all likelihood, the amount of monthly maintenance is being deducted from the said savings bank account and credited to the account of the petitioner. Stop. Accordingly, the matter shall be listed in the week commencing on 30/6/2026.
19.
Mr. Prabhas Pujari Parda for the petitioner.
Mr.
Mr. Polai.
My lord, I am appearing on behalf of Dipti Ranjan Mahapatra.
Mr.
Opposite
Polai on behalf of D.R. Mahapatra for the opposite party.
My lord,
I was filed for condemnation delay.
ये कॉपी देछन
Yes, Lordship, that was sir.
और adjournment चाहूँ
my lord, ମୁଁ adjournment ଏଥିପାଇଁ ଚାହୁଁଛି ଆଉ ଗୋଟେ RPM ଫାଇଲ କରିଛି ଯୋଉ ଅପୋଜିଟ ପାର୍ଟି ଇନ୍ଦୁଲତା ବେହେରାଙ୍କ ନାଁରେ ଆଉ ଗୋଟେ ପିଟିସନର କାଉନସିଲ ହିସାବରେ ଆଉ ଗୋଟେ RPM ଫାଇଲ ହେଇଛି ସେଟା 7 ତାରିଖକୁ ଆର୍ଜନ ଅଛି ଏଇ 7/5 ଅଛି ତ along with ତା ସହିତ
ସେଟା ବି ରାମଚନ୍ଦ୍ର versus ଇନ୍ଦୁଲତା
yes my lord
ନା ଲକ୍ଷ୍ମଣ versus ଇନ୍ଦୁଲତା ଯଦି ରାମ ହେଇନଥିବେ ତାହେଲେ ଅନ୍ୟ ହେଲେ
ରାମ ଅଛନ୍ତି ରାମ ଅଛନ୍ତି
Mr. Pujari says that no, how can you be so sure?
That might have.
Pujari knows better who is Rama, who is Lakshmana.
yes my lord
ମନା କରୁଛନ୍ତି ସେ କଥା ହୁଅନ୍ତୁ ବୁଝନ୍ତୁ ଜିନିଷଟାକୁ ମୋର ଅର୍ଡର ଟା ପୁରା ଭୁଲ ହେଇଯିବ ଆପଣ ବୁଝିବା ଦରକାର
yes my lord
କଣ କରାଯିବ 7 ତାରିଖ ସ୍ପେସିଫିକ ମାନେ this assignment of this bench ଦେଖନ୍ତୁ वो टैग करूनी बट 7 तारिख को अपन तो 7 तारिख को रखुन से स्पेसिफिक रखुन हैं ठीक है और अपन कागज से लिखि दो से वेरीफाई करी लेट अस नॉट स्पेंड टाइम देयर 7 तारिख को आसु
My humble request is that let the matter be taken up on 7 because I am paying 40,000 plus per month in view of the directions passed by the learned trial court lordship because it is a litigation which
से पूरा 18 महीने पेंडिंग अछि मैडम चौधरी मैडम सॉरी मैडम महापात्र आर्ग्यू करथिले एतरे 20,000 टका लेखाए से पाउछन ବର୍ତ୍ତମାନ calling for records of prescription and medical records of treatment. ଆପଣଙ୍କ 40,000 ସେଟା ସେ ଫାଇଲ କରିବେ। 8 ବର୍ଷ ସେଥିରେ 8 ବର୍ଷ ଯିବ।
Lordship, this litigation started
No,
from
no, you see that.
2004,
I
Lordship.
mean, what you are saying, actually, I am conscious of that. This is happening. Once the amount is paid, it goes on and on and on. ठीक है से आसु आपण मिस्टर कोलाई से केस नंबर टा दियन।
Yes, Mr.
Mr. Prabhas Pujari appearance देखिए ना। Is submitted by the Learned Counsel for the opposite Mr. Kolai appearing on behalf of the Learned Counsel for the opposite party that another matter is pending before this court between the parties आपण sure किसी कोईटा मना करछन emphatically
Sir, ghost title टा देखो।
which कौन लिखले another matter is pending which may be connected empty कर दिया which may be connected which may be somewhat connected empty करते somewhat connected with the present matter and is list and connected and is to be listed on and is supposed to be listed on 7/5/2026.
Yes, ma'am.
Accordingly, the present applications shall also be listed on 7/5/2026. नले आपण टी जो दिन गीत जाके इकट्ठी कर देबे टैग करिया दरकार नहीं।
Lordship, may I say?
Yes.
This RPFM, which my learned friend is indicating, that has been filed at the instance of the present opposite party. That means wife and the daughter, Lordship. It was heard on 2nd of May and it is further posted to 7th of May. If at all they are challenging the imputer, that might have been this.
Say enhancement चाहोगे?
Maybe, but there is a delay.
Let us see. Let us see that.
But my position is that let the matter be on 7 because I am not in the.
No, it is on 7. I have already said it.
Yes, grateful.
No, maybe you are reading, you did not listen to me, but I have said it. So number तक अपन टी दे दियो. Yes. Yes.
Grateful.
Yes, please. Mr. Rasmikant Acharya for the petitioner, opposite party. Mr. Mishra for the opposite party.
Yes. Matter become infructuous.
No, my lord.
Yes, ma'am.
I have a submission, ma'am.
Yes. ताको सुनो जानो first listen to him. You are rejecting his contention without listening to him.
As for the
Yes, Mr. Acharya.
As per the direction of the honorable coordinate bench, the petitioner have filed one petition to recall the order of ex parte order, my lord. Thereafter, my lord, ex parte order was set aside. Your lordship may see the order.
This देखिए जो
आगे हम
देखिए
जाए अच्छी
ओ ये अजय कॉस्ट भी देचन आपण अपेयर करछन सर मिस्टर आचार्य इज फॉर द पृथ्वीराज फॉर द वाइफ सीपी टा होची बिटवीन सीपी रे पिटिशनर की
I am the petitioner.
वाइफ इज द पिटिशनर सेक्शन 13 ना 9
27 the same
स्पेशल मैरिज एक्ट
seeking a divorce.
ओके अच्छा एक्सपर्ट ऑर्डर रे कोन हितला 31/25
My lord, on 30th of January 2025, your lordship, the main suit, it was posted. The IA, which is separate proceeding, that is for maintenance, that was also posted to 30th of January 2025.
IA arising out of the CP.
But there are separate orders, separate, it is posted also to separate dates. Now 30th of January, the husband.
But maybe separate, but arising out of the
arising out of the same 24 Hindu Marriage Act.
Yes.
Corresponding to Special Marriage Act.
Whatever.
Now the
24
now the husband took number of adjournments, didn't file the asset liabilities. I tried my best till date. Not a single rupee has been paid to me. My asset liabilities I have filed with zero income. I have stated everything. Now, what has happened, your lordship? On 30th of January, he deliberately remained absent. So the learned. So the learned judge, Family Court, Bhubaneswar, posted the CP to 25th February 2025 and posted the IA to 14th of February 2025. Now, he has challenged both the order in the CP and in the IA in the same read, which is prima facie not maintainable. And what he has submitted before your lordship, the order he is relying, the interim order he is relying, that is 12/8/2025, he submitted.
Just go through that. Can you just go through that? You have a copy.
Yes.
Please read that.
Paragraph 6.
Then the order dated 2/2/26.
ନାଇଁ 12/8/2025
ନା ନା ମୁଁ 2/2/26 ଦେଖୁଛି।
2/2/26 ଟା ମୋ ପାଖରେ ନାହିଁ ମୁଁ ଏଇଟା ଦେଖିଛି।
ସେ କହିଲେ ଅଛି ବୋଲି ମୁଁ ସେଥିପାଇଁ କହିଲି ଅଛି ବୋଲି।
ନା ନା ଏଇଟା ମୁଁ ଦେଖିଛି ଆଜ୍ଞା।
ଜଷ୍ଟ ପଢି ଦିଅ। ପଢନ୍ତୁ। Mr. Acharya, you have a copy?
Inadvertently,
नहीं नहीं ଆପଣ ପାଖରେ କପି ସେୟାର କରି ଦିଅନ୍ତୁ।
ଆଜ୍ଞା।
Timing just so that
the case record is put up today for, I am reading it loudly, my lord.
yes.
The case record is put up today for an order on the petition dated 29/8/2025 filed on behalf of the respondent, praying to set aside the ex parte order dated 30th January 2025. Objection already filed. Already heard on the petition from both sides. Peruse the case record. The respondent was set ex parte on 30th January 2025. As he was absent on repeated calls and no steps had been taken on his behalf. This is a matrimonial case. Law is well settled that a matter should be adjudicated on merit rather to dispose of on technical grounds, and so for the interest of justice and just decision of the case, and to give logical end to the controversies between the case, and to give a logical end to controversies between the parties for all time to come, the petition is allowed subject to payment of cost of ₹1,000 to be paid to the petitioner wife. The petition dated 29/8/2025 to recall the order in IA number 96 of 2024 dated 14/2/2025 is to be considered after filing of the written statement on behalf of the respondent. Put upon 12/3/2026 for filing of the written statement on behalf of the respondent.
IA record prayer thila?
IA prayer thila for interim maintenance, which has been allowed 10,000 per month. With it.
So that remains intact.
That remains
so
intact.
That is not against you also. But this order is not against you.
This order, your lordship, they have obtained on 12/8/2025 on a submission that the learned judge family court has posted it to 25th of February and advanced it to 14th February and passed the interim order, which is wrong, misleading.
नहीं interim order कौन कहले बुझ पाले नहीं।
से आज्ञा से मु आउथरे कहूचे आज्ञा 30 जनवरी 2025 रे पोस्टिंग हेतिला सीपी टा मेन केस टा
सीधा ये हे वाला
तेरे एक्सपर्टी
आपन पिटिशन ना एक्सपर्टी हे की
एक्सपर्टी है कि पोस्टिंग है गला 25 फरवरी 2025 को सेटा आज्ञा सीपी 723/2018
हां
सेही दिन आईए टा भी आज्ञा पोस्टिंग थिला आईए 90
आपनकर एक्सपर्टी जोटा सीपी थिला
आज्ञा
से 2/2/26 रो ऑर्डर इंपैक्ट हे हला जे एक्सपर्टी टा से रिटन स्टेटमेंट फाइल करिवे दैट मच नथिंग मोर नथिंग लेस
एक्सपर्टी मेन सूट रे
मेन सूट रे हला
आज्ञा मोर
जोटा आईए टा से तो कहिले जे परे आईए टा से देखो से रात्रे पढंतु
आज्ञा मु देखिले आईए टा कंसीडर
नहीं मो पार्टी तो नहीं जस्ट पढि दियो
नहीं मु आईए टा देखिले आज्ञा कंसीडर हबल लिखाई छी आईए इज टू बी
आईए कंसीडर हबनी से रिकॉल ना कोन कंसीडर
आज्ञा रिकॉल ऑफ द आईए एक्सपर्टी ऑर्डर
recall of the order. So recall of order केवल consider so that is also not against you.
आज्ञा
ताको written statement देला परे so he has to tolerate that.
May I submit my daughter?
Yes.
On 30th of January, the IA 96/24 was also posted. से IA टा
14/2/25 रे IA रे order हेची
14/2/25 रे order हैला से माने आज्ञा कोर्ट रे सबमिट कले
हां से सुनदु let us assume what you are saying maybe what you are saying technically may be correct that to certain extent they were not fair
आज्ञा
maybe but end result टा कोन हला सर
end result होचे आज्ञा end result होचे honorable court observe कले जे आपण जाई करे एई भूल हेतिबारु सिविल को लर्नेड कोर्ट नरा
गुड से ग्राउंड रे तो अलाउ हे नहीं
सेटा किंतु आज्ञा ऑर्डर हेची that was the order placed by
you are saying that what was told before this court
yes
is not factually maybe incorrect
आज्ञा
but when the recall application was filed for recalling the order dated 30th January 2025 the ground is that give me a chance to file written statement explain that much
that is on the basis of this order
nothing less that no
मु आज्ञा टिके ऑर्डर टा मु ऑर्डर टा पढुचे
you read again 2 order
ने मु टिके आज्ञा 12/8/2025 this honorable court's order मते आज्ञा
आपण बुझ पर ना मु गोटे कथा कहू आपण आ गोटे कथा कहू we are proceeding parallelly when the order dated 2/2/2026 is filed the court has considered the application for recall whether आपण कहउछन जे सेटा that was persuaded by this court being wrongly influenced by the so that is not there even if assuming that they have wrongly influenced the high court that has not resulted any prejudice to you कहउछंती जे सेटा हाई कोर्ट जोडा कहले सेटा ठीक नो maybe you are right
ना मु सेटा तांको सबमिशन आज्ञा से माने डेलिबरेटली सेटा को प्लेस करचंदी
whatever
More, then your lordship may consider. No, your lordship may consider. There is an order that from 2 to.
ଆପଣ କଣ ଯୋଉ ଦୁଇ ଦୁଇଟାକୁ କହୁଛନ୍ତି ଭୁଲ ଅର୍ଡର ବୋଲି?
ନାଇଁ ଦୁଇ ଦୁଇଟା ମୁଁ କହୁନି ମୁଁ ଆগে କହୁଛି
ଦୁଇ order does not prejudice you.
ନାଇଁ ମୁଁ my submission is
regarding the maintenance order.
yes.
The court is has not passed any order actually. Rather, the maintenance order is also restored. I mean, it remains as it is. ଆପଣଙ୍କର the IRA maintenance order ହଉଛି 14/2/25.
ଆଜ୍ଞା
14/2/25 order still remains intact, untouched, not touched by this court or the trial. Nothing has happened.
ଆଜ୍ଞା
So, as far as this application, the prayer କଣ ଥିଲା?
এই application ରେ prayer ହଉଛି ଦିଟାଙ୍କ order set aside କରାଯାଉ 30th of January 2025
14/2 cannot be set aside. So that he have you marked Mr. Acharya's stand? He never said anything. He simply said infructuous. So why you are saying that 14/2 will be set aside?
why my lord my submission no my lord
pressing 14/2/25. Why I will hear whether 14/2/25 is to be set aside or not? Because he is not pressing it.
now because of the interim order by this court they got the advantage of filing ex parte set aside. That is the observation. Paragraph 6 12/8/2025
ନାଇଁ ଆପଣ again 12/8 ରେ ଆପଣ obsessed ହେଇଗଲେଣି।
ନାଇଁ ନାଇଁ ଆଜ୍ଞା ମୁଁ ସେଟା
2/2/26 କୁ ଆସନ୍ତୁ 2/2/26 order ରେ 12/8 has not played any role.
that is a CP.
Yes.
So far
IA is arises out of the CP. There is a maintenance order in CP. Though it is challenged in the present application, Mr. Acharya, he is very clear. He is not pressing that. That's it.
my prayer is that
So why should the court should spend time hearing from you whether 14/2 should be recalled or not? When he is seeking recall, he is not pressing it.
my prayer is that your lordship that I am the
ସେତେବେଳେ ଆପଣଙ୍କର ସେଇ ଯୋଉ ଇନିଂସ ଯେତେବେଳେ ଆରମ୍ଭ ହବ ସେ 14/2 ଚ୍ୟାଲେଞ୍ଜ କରିବେ ସେତେବେଳେ କଣ ହବ nobody knows. ସେତେବେଳେ ଦେଖାଯିବ
ମୋର ମେଣ୍ଟେନାନ୍ସ ଟା 2/12/2024 ରୁ ଷ୍ଟଲ ହେଇକି ରହିଲା because of this only they have got it straight
2/12 ରେ କୋର୍ଟରେ ଷ୍ଟେ ହେଇଛି
from 2/12/2024
କୋ ଆପ୍ଲିକେସନ
এই present WP
leave it there sir when all is well that ends well
my lord then for
everything goes sir the interim order goes everything goes when he is not pressing 14/2 ମୁଁ କାଇଁ ପଚାରି ଆପଣ 14/2/25 ବିଷୟରେ recall ହବ କି ନାହିଁ address କରନ୍ତୁ court କୁ when he says the petition has become infructuous
area 1,60,000 I am not getting anything my lord
execution କରନ୍ତୁ
I am not getting anything
pension ଯେମିତି ଆଟାଚ ହେଇଛି କହିଲେ ମିଷ୍ଟର ରୋତା ସେମିତି ଯାହା ତାଙ୍କର ସେ କଣ salary holder ନା କଣ
ନାଇଁ he is working as a professor
ବଢିଆ କଥା
no he is not yet filing even asset liabilities
ସେ ନ କରନ୍ତୁ
these are only the tricks played my lord
I understand sir ସେଟା ଆପଣ ଯେତେବେଳେ ଆଡଭାଇସ୍ କରୁଛନ୍ତି ସେଟା ମିଷ୍ଟର ଆଚାର୍ଯ୍ୟ ଫଲୋ କରିବେ ଆପଣଙ୍କୁ ଯେତେବେଳେ ପ୍ରଫେସର ଆସିକି ନେଲେ ଆପଣଙ୍କ ଆଡଭାଇସ୍ ଆପଣ ଏଟା ଆଡଭାଇସ୍ କଲେ ଆରେ ଆଜ୍ଞା ଗୋଟାକରେ କଲିଂ ଫର ରେକର୍ଡସ୍ 8 ବର୍ଷ ପରେ ଫାଇଲ ହେଇଛି ୱିଲ୍ ବି ସରପ୍ରାଇଜ ସେ ରେକର୍ଡ କଣ ସେ କାହିଁକି ଫାଇଲ ହେଇଛି ବୁଝିପାରିବେନି maintenance is 20,000 wife has filed calling for records see regular maintenance is granted 20,000 because he is a government servant
ଆଜ୍ଞା
so କଣ ସେଟା ଷ୍ଟ୍ରାଟେଜି ଆପଣ ମାନଙ୍କର ରୋଲ ଅଛି କି ତାଙ୍କ ରୋଲ ଅଛି ସେଟା ମୁଁ କହିପାରିବି ତାଙ୍କର ମାନେ କ୍ଲାଏଣ୍ଟ ଆପଣ ମାନେ both of you that is happening sir
I have filed also an IA
sir these cases are being lingered and I mean for many reasons you are right there
my submission I have filed an IA 19562/2025 long back in October 2020
ବର୍ତ୍ତମାନ they have been beaten back by you successfully
ନାଇଁ ସେ ଆଜ୍ଞା କିଛି amount ମତେ something they have to pay
ସେ କାଇଁ ଦେବେନି ଆରେ how can I presume ସେ ଦେବେନି ଟ୍ରାଏଲ କୋର୍ଟର କଣ ପାୱାରଲେସ୍ ହେଇଗଲା
ନାଇଁ ଆଜ୍ଞା ସେଇଟା
when the trial court has itself restored it and interestingly when it has restored here it has said that it will be considered in future after you file written statement
let it be they let them pay the amount area and your lordship may dispose of the writ in that line
that is completely beyond my jurisdiction I am not executing court not the execution is pending before me if they challenge then I get some power to ask them if I want to challenge as I have been asking you secure the amount deposit there deposit here still they are not listening to me you understand and every court cannot pass the orders of arrest and detention
no seta that I understand
the appellate court has this that appellate or regional court has this problem because it's not the executing court
but the fact is that my lord petitioner
your point is well taken that initially when they got the interim order maybe they did not
taking advantage of it they have filed the ex parte set aside because it is observed by your lordship that you file ex parte set aside petition.
You will be surprised in one matter after the CP is withdrawn because 24 order is there.
Again.
Mr. Parija was appearing. I mean the senior most counsel. civil bar president. You are surprised. Instead of arguing, the council stands up, nothing survives because 24 is no more there. Why 24 not there? CP has removed. So legal strategy, I mean, it depends on all of you, how to drag it and how to delay it.
May I make a small submission, madam?
Please.
Your lordship may
So
consider.
you have made all the big submissions. What is left in the small submission?
My prayer is that, your lordship, this is a read they have filed, and this is the scenario what has been placed. Now, since 2/4/2022, 2/12/2024, there is an area of 10,000 per month.
Effort debeni trial court re problem hobo hi hobo.
Let them
Despite
pay.
you being said, you see, despite he being said ex parte, could you not have filed the execution? Could you not file the petition here again? They have been set ex parte. Ex parte hoba ko challenge kale, seti downanti maintenance. Very simple.
Seta stay hiche agya.
Kota ex parte ta stage na maintenance ta stay hiche.
Maintenance ta stay hiche.
Seta then you are right in blaming me. Maybe I was part of being High Court also.
My prayer is that, your lordship, that order they got stayed. Now they are withdrawing it. Learned court set aside.
They are not withdrawing.
The withdraw memo file
because you made these submissions, they realized that now court will pounce upon us. They simply went there and filed the petition. ବର୍ତ୍ତମାନ ଯଦି ସେ ସେଠି ଫାଇଲ କରି ନଥାନ୍ତେ ଆପଣ ତାକୁ ଛାଡି ଦେଇଥାନ୍ତେ ବର୍ତ୍ତମାନ
ନାଇଁ ବର୍ତ୍ତମାନ ଆଜ୍ଞା ମୁଁ ଏଟା
ଏକ୍ସପର୍ଟ ହେଲା ପରେ ଏଠି ଆସିକି ଷ୍ଟେ ନେଇଛନ୍ତି ଦେ ହାଭ୍ ବିନ୍ ସେଟ୍ ଏକ୍ସପର୍ଟ
ମୁଁ ସେଟାକୁ ଭ୍ୟାକେଟ୍ କରିବା ପାଇଁ
ସେଟା ସେ ବାଧ୍ୟ ହେଇ ସେଠି ଗଲେ
ଆଜ୍ଞା ମୁଁ ସେଟା ଭ୍ୟାକେଟ୍ କରିବା ପାଇଁ ଆଇ ଫାଇଲ କରିଛି
କରେକ୍ଟ
ନାଇଁ ମୋ ପ୍ରେୟାର ଇଜ ଦ୍ୟାଟ୍ ମାଇ ଲର୍ଡ ସମ୍ ଆମାଉଣ୍ଟ ଆଇ ମେ ବି ଗେଟିଂ
no I cannot because I have not directed any amount. You must understand
that order remained stayed. I didn't get anything. Now your lordship will
ଆପଣଙ୍କର ଷ୍ଟେ ବି ହେଇଛି କେବେ
ଆଜ୍ଞା ସେଟା ହେଇଛି ଆଜ୍ଞା
12/8/25 ରେ ତା ଭିତରେ
ମୁଁ immediately 1 month ପରେ ଫାଇଲ କରିଛି to vacate this stay.
ନାଇଁ ଆପଣ ବୁଝିଲେ ଆପଣ ଠିକ ବୁଝୁଛନ୍ତି ତାପରେ ଆପଣଙ୍କର 14/2/25 ରେ ହେଇଛି ମେଣ୍ଟେନାନ୍ସ ଷ୍ଟେ ହେଇଛି 12/6/18
ନାଇଁ 14/2/25 ରେ ଅର୍ଡର ହେଲା to pay it from 2/12/2020 ଆଜ୍ଞା
ଫାଷ୍ଟ ଅର୍ଡର କେବେ ହେଇଥିଲା
ଫାଷ୍ଟ ଅର୍ଡର ହେଇଥିଲା ଆଜ୍ଞା 14/2/2025 ରେ
ସେ ତ ଯଦି ତା ପୂର୍ବରୁ ଅର୍ଡର ଥାଏ exactly for 6 months you have also sat over it
ମୁଁ
ଆପଣ ଯଦି ଆପଣ ଯୋଉ କହୁଛନ୍ତି ହାଇ କୋର୍ଟ ମେ ବି ୟୁ ଆର୍ ରାଇଟ୍ I take the blame. I mean no difficulty କାହିଁକି ନା I have passed the order staying there but till ଆପଣଙ୍କର for 6 months also you could have filed execution.
True,
and
my
that
lord.
would have helped you.
I have got a right to club 1 year's maintenance. So to either 6 months, 8 months or 10 months, I can club it within 12 months. That is the right of execution.
I'll observe that. You'll proceed in I'll note your anxiety in that what you have suffered. That I will note and I'll pass direct that you will take appropriate step in accordance with.
Because your lordship, even 125 corresponding to 144 BNSS, it is clear provision that when an ex parte order is 24, this is 24. Even it is clearly stated that while setting aside an ex parte order, the court may impose cost and this area amount that is to be.
1000 ଟଙ୍କା product ହେଇଛି
ସେଟା ସିପି ରେ କଲେ
obviously expert order ଟା ସେଟା ସେଟ୍ ସି କରିବେ ନା ମୁଁ କେମିତି କରିବି
interim maintenance portion has not been.
ଆପଣଙ୍କର maintenance partly maybe that trick that has been played but what can be done. Mr. Rasmikant Acharya for the petitioner, Mr. Ashutosh Mishra for the opposite party, the learned counsel for the petitioner submits that they produces copy without a memo sangare diyo कागज तो दियो सर इटा गोटे मेमो सर फाइल कर produces files memo of date in fact if you see the earlier orders by the coordinate bench nowhere this aspect has been raised actually. I don't know, maybe you have raised.
नहीं सेटा ऑनरेबल कोर्ट कहले जे मु ऑब्जर्व करने आपण दे जण ट्राई करी की सॉर्ट आउट कर दियंतु इफ समथिंग कैन बी डन
आपण कथा सुनिले नि मिस्टर
ना मु आई रिक्वेस्टेड इन सेवरल टाइम्स
entitled to get any maintenance
that is their
concern is that earlier the petitioner has filed one petition under section 19
provision no बोली कहउछन
because I'm saying is because my your lordship may see the
And
order.
it can't be the ifse dixit of a person. ଆପଣ ଗୋଟେ legal submission କରନ୍ତୁ. ସେମିତି ଆଜ୍ଞା ଏପର୍ଯ୍ୟନ୍ତ ମୁଁ କାହାକୁ ବି ଦେଖିନି ଯେ କଣ entitled.
Earlier
Reason କଣ ଆପଣ?
reason ଟା କହୁଛି my lord. Earlier petitioner has filed one petition under section 98 of
ଆପଣ submission
CRPC.
କଣ କଲେ ଆପଣ କହିଲେ she is not entitled ଆପଣ display କରିବାକୁ ପଡିବ.
Your lordship
Entitled to receive any maintenance. So that is how I'm asking you what is the provision. କାଗଜ ପଢାନ୍ତୁନି submission କରନ୍ତୁ. Develop a habit of being point blank straight away submission କରନ୍ତୁ. ଚିଠା ପଢୁଛନ୍ତି କଣ? କାଗଜ କଣ ପଢୁଛନ୍ତି? କଣ point କଣ straight argue କରନ୍ତୁ.
ସେ ଗୋଟେ WS ରେ କଣ ସେ ଲେଖିଛନ୍ତି
ସେଟା W ସେଇ ତ problem ଆଉ। ସିଏ ମହାଶୟ ପ୍ରଫେସର ସେ କଣ law professor? ସେ ଯାହା କହିବେ ଆପଣ ସେଟା ସେ କୋର୍ଟରେ କହିବେ। Make a legally nuanced submission.
They are denying the marriage, my lord. That was
ଆଜ୍ଞା ମ୍ୟାରେଜ ନଥିଲେ ମେଣ୍ଟେନାନ୍ସ ପାଇବେ ବୋଲି ବହୁତ law evolve କରିଗଲାଣି। Marriage cannot, it need not be
Even in void marriage.
void or voidable, whatever,
Yes,
any
sir.
kind of relationship. And domestic violence, financial assistance between any parties.
Here the marriage is
ଆପଣ ତାକୁ
registered.
law ପଢେଇବେ ନା ସିଏ ଆପଣଙ୍କୁ law ପଢେଇବେ? Don't make submissions like this. I'm really concerned because the reason being that we are behaving as if we are common men, we do not know anything. ଯିଏ ଯାହା ଆପଣ ଚାମ୍ବରରେ କ୍ଲାଏଣ୍ଟ କହିଲା ସେଟାକୁ ଆସି ଏଠି କହିଲେ। ଆପଣ ଯଦି deny କରୁଛନ୍ତି that is it is very clear in 125 there is a direct decision.
She is denying.
Whether marriage or maybe she deny but she can claim.
My lord,
ये
on
कौन सही प्रोफेसर जो संबलपुर रे?
ନାଇଁ ନାଇଁ ଇଏ ଡିୱାଇ ପାଟିଲ ମହାରାଷ୍ଟ୍ରରେ ୱାର୍କିଂ ସେଟା ସେ ଲୁଚେଇକି ଥିଲେ ଏଇ ଆଫିଡାଭିଟ ରୁ ମୁଁ ଜାଣୁଛି ତାଙ୍କ ଆଫିଡାଭିଟ ରୁ ମୁଁ ଜାଣିଲି ହି ଇଜ ୱାର୍କିଂ ଏଜ ଏ ପ୍ରଫେସର ଇନ୍ କେମିଷ୍ଟ୍ରି ଡିପାର୍ଟମେଣ୍ଟ ଡିୱାଇ ପାଟିଲ ଇଣ୍ଟରନ୍ୟାସନାଲ ସ୍କୁଲ ନଭି ମୁମ୍ବାଇ ମହାରାଷ୍ଟ୍ର ଏଇଟା ତାଙ୍କ ଆଫିଡାଭିଟ ରୁ ଏବେ ମୁଁ ଜାଣିଲି ଫର ଦି ଫାର୍ଷ୍ଟ ଟାଇମ ବିକଜ ଦେ ନେଭର ଡିସକ୍ଲୋଜ ଦେୟାର ଏନି ଇନକମ୍ ଏନି ପ୍ରେଜେଣ୍ଟ ପୋଜିସନ salary nothing. Now the affidavit at page 9 of the read, I could know their occupation as a professor.
Very similar cases. Oh no, council का नाम होना चाहिए. This is from Sambalpur. I know the place. Sambalpur and Kendrapada. Very similar. Then after the argument was over, then it was told that she was the student there. Only. Enclosing copy of the order dated 2/2/2026. Passed by the Learned Judge Family Court Bhubaneswar in CP number 723 of 2018. The said order is reproduced here. Okay, quote कर देते हैं. The Learned Counsel for the opposite party is heard at length. He submits that while moving the writ application, the petitioner has conveniently also sought for intervention of this court in the order of maintenance passed in IA number 96 of 2024. Order dated, order of maintenance dated 14/2/2025, passed in IA number 96 of 2024, arising out of the CP. So, to support his submission, he submits that the petitioner never disclosed before this court that he is in default in paying the maintenance as directed by order dated 14/2/2025. And the order dated 12/8/2025 passed by the coordinate bench at paragraph 6 directly observing that the petitioner can move the Learned Judge Family Court for setting aside ex parte.
My lord.
For setting aside the ex parte, for setting aside the order, setting aside for recall of the order dated TRC.01.2025, setting the present petitioner ex parte in the CP. Yes. Full stop. Stop. It is submitted by the counsel for the opposite party that in the process, the petitioner has stalled the proceeding, approached this court. This court expressed opinion of moving the trial court, and for the entire period since 14/2/2025 na ତା ଗୋଟେ order ନାହିଁ ମନା କରୁଛି
ନାଇଁ
14/2/2025
order ହେଇଥିଲା
for the
2/12/24
last more than 1 year he has not paid any maintenance.
ସେଇଟା order ହେଇଥିଲା 2/12/24 ରୁ ଦବା ପାଇଁ
That was to be paid maintenance, that was to be paid from the date of filing of application
2/12/2024.
Stop. Mr. Acharya, the Learned Counsel, the Learned Counsel for the petitioner referring to the order dated 2/2/2026 submits that the petitioner will not press the writ application any further as now he has been allowed to file a written statement. Stop. Stop. Obviously, the other prayer regarding setting aside of the order dated 14/2/2025 would also no more survive in view of the direction of the Learned Judge Family Court that after filing of the written statement, the prayer of the petitioner before the Learned Judge shall be considered. Stop. At this stage, it would suffice to observe that the petitioner shall have the liberty to move the petitioner upon opposite party. Upon opposite.
ଆଜ୍ଞା
CP ଟା ଆପଣ ଫାଇଲ କରିଛନ୍ତି 30
ଆଜ୍ଞା
କଣ ଲେଖିଲେ ତ पैसा पूर्व has been observed. Opposite party filing of repeated statement by the opposite party. That was the prayer of the opposite party. Any further prayer of the opposite party. Consider that. At which stage it would suffice to observe that the petitioner before the Judge Family Court shall have the liberty to pursue the legal remedy available to her for receiving the maintenance directed by order dated 14/2/2025 with effect from 2/12/2024. The writ petition is disposed of with the appropriate applications. There's a memory login that they do. That is of. Yes, please. Next. Mr. Bharat Bhushan Rao.
31.
After vacation, Lordship. Yes. Adjournment is sought for by the Learned Counsel for the petitioner on ground of personal difficulty. The matter shall be listed in the week commencing. As prayed for, the matter shall be listed for orders in the week commencing.
22. 143 delay.
Mr.
The ex parte judgment passed by the Learned Judge Family Court, Kendrapada.
Yes. What is the merit of a point?
Because the ex parte judgment.
Expert केबे सेट हेले चैलेंज कले कि नाही काहे चैलेंज कले नी काहे सेट एक्सपर्ट हेले
because the
जस्ट आपण सुनिले एते सब गोटे अधरडे चलला एक्सपर्ट
the present petitioner is serving as a havildar.
नोटिस केबे सफिशिएंट हला केबे एक्सपर्ट हेले ऑर्डर चेक देखा
Sir,
examine करो सर. Let us not make a half-hearted attempt in addressing the matter.
My lord, because the present petition came to know that there is a ex parte judgment.
Court knowledge, sir.
My lord.
Court sets you ex parte when court has the knowledge that it has been served and you are not pursuing. Expert is not a perception of the client. गोटे क्लायंट जेतले नोटिस हैला सफिशिएंट हैला से गलानी कोर्ट जदि नोटिस सफिशिएंट हेछि आपण कहउछथि जे आपण क्लायंट जान नथिले एबे जानिले तो सेटा ताको परसेप्शन नो यू हैव टू गो बाय द कोर्ट्स रिकॉर्ड केबे नोटिस इशू हेतला केबे सफिशिएंट हैला simply because it is an expert judgment the high court doesn't get jurisdiction to interfere please appreciate that the 227 na the revision
No, it is
a revision still work
revision.
227 with two revision hourly limited
Yes.
आपण से ऑर्डर आगे देखिछन्ते आपण जे को ऑर्डर एक्सपर्ट हेछन्ते से
Expert order the judgment re we came to know that the judgment re
definitely
expert
हैला तो आपणकर
judgment re expert hela as
को ऑर्डर रे हेले
that is the order
आपण धरंतु नोटिस बिल्कुल आपण इशू करा हेनी
notice has not been issued.
किम जानले सेटा
We came to know that after
so that is that's a leading question to you
yes sir.
आपण आंसर दे देले आपण नोटिस इशू करेने बोल किम जानले
After passing judgment we came to
आफ्टर पासिंग जजमेंट जाना पड़ियो ऑर्डर शीट देखियो पड़ियो इट कांट बी सेकंड गेस्ट बाय मच लेस बाय ए कोर्ट
yes
आपण क्लायंट तो छाणु से जा कले कले आपण किम जानि मु किम जानि आई कैन नॉट एट्रीब्यूट टू ए कोर्ट दैट आई नोटिस इशू न करी एक्सपर्ट हे गला देखो पेज 14 देखो पेज 14 पारा 3
yes
आपण ब्रीफ रो पेज 14 देखो
yes sir.
पारा 3 पढो
Right.
आपण कोन उल्टो जिन नाही से पेज
Para 3 the present person was initiated divorce proceeding party
को
bites
पृष्ठा पढुछन
sir petition ro 3 page ta
3 पेज 14 पेज आपण कहूची 14 पेज पारा 3 आपण तो उल्टे देले
right
जजमेंट रे इंटरनल पेज देखो
yes
पढो को देखै
on a receipt of summon as the opposite party did not appear he was set ex party violated
10 20 24
no
have you challenged that order
no sir
oh you should not sustain you can't have a third or fourth innings here 9 10 24 चैलेंज करिवार थिला सेते बेले
yes
नले सेटिंग एसेट एक्सपर्ट ताबी चैलेंज करिवार थिला nothing can be done
because I came to know from after getting judgment
the court knew from the stamp report your knowledge is not court's knowledge Please
yes ma'am
appreciate
yes
that.
ma'am
what
yes.
you are arguing is your knowledge
yes
that is the weakest point you can argue
yes my lord because
ignorance is bliss always but absolute ignorance becomes this problem ମୁଁ ଏଟା ଜାଣିନି କଣ ହେଇଗଲା
no no sir this is the trial court practitioners he can appear sir because there is a
whatever sir ଯାହା ହେଇଛି ହେଇଛି ଆଉ କଣ କରାଯିବ
yes because
ଆପଣଙ୍କର appear ନ କରିବାଟା court କୁ respect ନ ଦବାଟା has become fatal
yes ma'am that
so
is
these court cannot give that imprimatur
yes that is
so
done by
dismiss
the
today or another day
my lord,
but today I have not dismissed any ସମସ୍ତେ adjournment ନେଇଛନ୍ତି ଆଜି dismiss ହବ ନା ଗୋଟେ ଦିନକୁ ରହିବ
dismiss girls. I would be not sir
ଠିକ ଅଛି had learned counsel for the petitioner at some length that this is item 22 so Vijayananda Das for the petitioner the petitioner husband is before this court kindly just have your seat and just take some time the petitioner husband in the marriage is before this court seeking revision of the judgment dated 8/7/2025 passed by the learned judge family court Kendrapada in criminal CRL proceeding number 207 of 2022 the said proceeding was initiated by under section 125 of CRPC into bracket since repealed and substituted by perimeteria provision section 144 of DNSS by the wife in the marriage the marriage being solemnized on 7/6/2011, seeking monthly maintenance. Prior to filing of the the application under section 125 CRPC, the present petitioner husband had initiated a divorce proceeding under section 13 into bracket 1 into bracket I-A of Hindu Marriage Act against the petitioner against his wife, present opposite party, that is CP number 300 of 2015, which was dismissed on contest. The petitioner was receiving rupees 13,390 per month towards maintenance, which was stopped by a letter dated 24/9/2022. It is submitted by the learned counsel for the petitioner that the petitioner is not aware of the judgment. You should have examined this aspect. He had filed a CP, was dismissed. After dismissal of the CP, the maintenance granted under 24 was stopped.
I have
You should have
noted in
asked this. You should not have, court answerless and motionless in court, because you have not asked him these questions. You have raised a false plea before this court.
I have brought that fact in my petition.
For judgment, the court has considered that.
No. The petition is there. My
No, absolutely no merit, sir. He's not fit to be Havildar even actually. He's a disciplined force. He plays tricks with the lawyer and tricks with the court. Retinal etis, retinal eti, kote kichode coin. No. Judgment. A judgment dated 8/7/25.
in para 3 I have cited
Just
in my petition.
no. Apparently, the perusal of the judgment of which revision is sought for indicates that notices on the petitioner herein was sufficient. For the reasons best known to him, he has not stated regarding the notice in his present application seeking revision, which speaks volumes about his conduct. It has been observed by the learned family court that after receipt of notice, since the opposite party husband did not appear, opposite party husband as present petitioner did not appear, he was set ex parte with the order dated 9/10/2024. On being asked, the learned counsel for the petitioner submits that he has no instruction whether an application was filed to recall of order setting the present petitioner ex parte. Stop. Prima facie, the plea of not being aware of the judgment is unsustainable in the facts and circumstances of the case. The court has taken note of the fact that the present petitioner is working as a Havildar in Indian Army and get salary of rupees 60,000 per month. Apart from that, he has 6 acres of landed property, of which the record of rights were produced and marked as exhibits before the trial court. Further exhibits were marked and proved before the learned trial court regarding the property owned by the family of the petitioner, of which the petitioner himself is. The learned counsel for the petitioner is apprised of the judgment of the Honorable Apex Court in Samima Faruqi versus Sahid Khan, wherein the learned Apex Court have authoritatively dealt with the scope of interference in exercise of divisional jurisdiction of this court in orders passed by the trial court, public family court, in proceedings under section 125 of CRPC, paragraph 19 and 20 of Samima. The learned counsel seeks and has adjournment. The matter shall be listed for orders in the week commencing on 6/6/2024. Copy of this order shall be forwarded to the learned judge, family court. To be kept in the records of CRP number 207 of 2022, decided on 8/7/2025. Yes. Yes, next.
23, may I please go.
The summary, Mr. for the appellate, Mr. Bhavan Mahanti for
I'm appealing
the
for
respondent.
OP number 124 MFA.
Summary, Mr. for the appellate, Mr. Bhavan Mahanti for the. Now this is Bhagavan with Prabhu. So imagine what will happen to Tanmay. So Prabhu Prasanna Behra for OP number 5. 6 के standing counsel notice to go.
Notice to go.
Okay.
Notice has
Yes, Mr.
had been issued.
Notice have been issued
Okay.
by order dated now with service.
Lordship. The noting says that AD has returned after valid service.
The office note indicates that notice issued to the OP number 6 by order dated now with service has been returned after valid service. Awaiting appearance of the OP number, the respondent. Respondent 6. The matter shall be listed for orders from the week commencing. For 7/2026. Interim order किछि अछि?
No, this is the IA for continuation of delay.
Okay. So
I'll file counter.
The learned counsel for the appearing opposite the learned counsel for the opposite parties, the respondents who have already appeared shall have the liberty to file the response to the IA seeking confirmation of claim. Court fee has been extended already. Deposit of court fee you have deposited.
Yes, that your lordship has recorded in the last order.
Yes.
9-2 order, lordship has already issued.
This is order number 2. Second. Yes.
Obliged.
24. May I please, yes. Item 24 on behalf of Amitabh Tripathi.
You are Mr. Das.
Kaushik Maharana.
Mr. That's your power, Mr. K.K. Maharana. For the
Notice was issued, but it was returned back. The D2 address was not located.
let us have it. Technically, 80 not back mane sufficient kari Office note, the learned counsel for the petitioner refers to the office note, which indicates thus regarding the service of notice. The court code. Awaiting appearance of the opposite party and awaiting sufficiency of notice, public appearance of the opposite parties. The matters shall be listed in the week commencing. Listed for orders.
No, sir.
6/7/2026. Interim order thila.
No, sir.
Okay.
Obliged.
Yes.
25.
Mr. Akshay Kumar Sahoo for the petitioner. You are also Akshay Kumar Sahoo. There are so many Akshay Kumar Sahoo. Yes. IAS 6 of 2026 for correction of cost item.
My lord.
କଣଟା ସେ schedule ଦେଇଛନ୍ତି correction ର schedule ଟା ନା କେମିତି କରିବେ correction? ଆଜ୍ଞା corrected cost item ଟା ବି ଦେଇଛନ୍ତି
ଆଜ୍ଞା
Black mark ହେଇନି
I have filed.
କୋଉଠି ରେକର୍ଡ ଆପଣ ଫିଜିକାଲ କପିରେ ଅଛି ନା? Black mark ନ କଲେ ମିଳିବ କେମିତି? ଆପଣଙ୍କର IAS ସାଙ୍ଗରେ ଲଗା ହେଇଛି କୋଉ IA ଟା କହିଲେ? IA ନମ୍ବର 6
6 of 2026.
cost item ଟା କୋଉଥିରେ ଲଗେଇଲେ?
IA 6 of 2026.
ଏ ମୁଁ ତ ଭୁଲୁନି ସେଟା ଫିଜିକାଲ କପିଟା ଦେଲେ
Flag B ରେ
ଆଇଲେ
ଅଛି.
cost item ପାଉଛନ୍ତି
Flag B ରେ ଅଛି.
Black mark IA ଟା ଅଛି କିନ୍ତୁ cost item କୋଉଟା କିଛି ମିଳୁନି IAS 6 is there.
Yes, of course.
ଗୋଟେ ଲେଖା ହେଇଛି ଯେ type corrected cost item received from counsel for the petitioner kept with records.
Yes.
ଉପରେ ଅଛି ସେଟା
It's correct. Correct.
କୋଉଠୁ ପାଇଲ? ଆପଣ ଖାଲି ଗୋଟେ ପେଜ କରେକ୍ସନ କରିଛନ୍ତି ଦେଖିଲେ ଏଇଟା
ଗୋଟେ ପେଜ
ପୁରାଟା ନହେଲେ ସେଟା କେମିତି କରେକ୍ସନ ହବ କେମିତି ଆପଣ ପୁରାଟା ଦେବେ ନା ଆଇ ହୋପ ୟୁ ଅଣ୍ଡରଷ୍ଟାଣ୍ଡ ହ୍ୱାଟ ଆଇ ଏମ୍ ସେଇଂ ସେଇ ପେଜଟା ରିପ୍ଲେସ ହେଲେ ହେଇଯିବ ତାକୁ ଦେଖିବେ ନା ମତେ ଦେଖିବେ ଏଇ ଯୋଉ ପେଜଟା ଲେଖା ହେଇଛି କରେକ୍ଟେଡ କଷ୍ଟ
ମୋର ଭୁଲ ହେଇଥିଲା ଫାର୍ଷ୍ଟ ପେଜ ରେ
ଫାର୍ଷ୍ଟ ପେଜଟା ଚେଞ୍ଜ କରିଦେଲେ ହେଇଯିବ ଦ୍ୟାଟ୍ ଇଜ ହ୍ୱାଟ ୟୁ ଆର ସେଇଂ
ଏଠି କଷ୍ଟ ହେଇଥିଲା ନିଜ ଲେଖିଥିଲି ସେଟା ଭୁଲ ଲେଖି এইটা কষ্ট তো পূর্ণ ଥିଲା ଏଇଟା ପଛରେ ଦେଖିଛି ପୁରା ସେଟ୍
ଆପଣ କରେକ୍ଟେଡ କଷ୍ଟ ଯୋଉ 1 2 3 ଦେଇଛନ୍ତି
ଆଜ୍ଞା
ସେଟା ହେଲେ ହେଇଯିବ ସେତିକି
ଗୋଟେ ଅଛି
ପେଜ 2 ଟା କଣ
ପେଜ 2 ଟା
ଠିକ ଅଛି
ମାର
ଦେଖିଲେ ପେଜ 2 ଟା ଆପଣଙ୍କର ପିଣ୍ଟୁ ଅଗ୍ରୱାଲ
ଆଜ୍ଞା ପିଣ୍ଟୁ ଅଗ୍ରୱାଲ ଏଜେଣ୍ଟ
वर्सेस देवकी नंदन
धानुका
डिस्ट्रिक्ट चाइल्ड प्रोटेक्शन देखो डिस्प्ले
मार
से वांटा ताले हिजो कॉस्ट है तो
मारला
ठीक है submitted by the learned counsel for the petitioner that as observed as liberty granted as per the liberty granted in order dated 10/3/2026 he has filed as per the liberty granted by order dated 24/2/2026 he has filed the type corrected cost item that is page 1 of the cost item which is on record. Office shall do well to replace the earlier cost item by the corrected page 1 of the cost item. The page 2 of the cost item remaining as such. Delay in notice जाएनी ना कौन 787 days delay. IA 2 of 2026, the IA has been filed for reported for condonation of reported delay of 787 days in filing the appeal, challenging the judgment dated challenging the order dated 29/8/2023 passed by the learned judge family court Hon'Ble. It's CP number 53 of 2021. Case number CP number 53 of 2021.
Madam.
Heard by the counsel for the petitioner. Appellant. Issue notice on the question of condonation of delay to the opposite parties by opposite parties as indicated in the corrected cost item by speed post with registration and proof of delivery. List after SR liberty to lecture. Mr. Das को data if गले में just ठीक है पढ़ेंगे. Mr. Das ने कहे PK Das. Well, please wait. I have something to discuss regarding yesterday's hearing. Yes, in that matter, what I could find that there is no positive evidence regarding income of the husband.
Right.
So you talk if it can be reduced from 10,000 to 8,000.
Yes.
Okay. You said that yesterday. You said
absolutely.
Whatever Lordship says.
But
ସେଇଟା ଯେହେତୁ clearly discussion ହେଇପାରିଲାନି because of paucity of time. That much I will do. Yes.
Item 26.
26 hearing matter, I don't think I'll be able to open the briefs.
My lord.
By simply opening the briefs, I will not be able to conclude.
Only thing I have it there.
Please.
So Lordship may kindly fix a date because they are working for the last 29 years, 30 years. It is for regularization of their services.
So
And
what
one
is
is
for
going
the
to retire in the month last week, last 30th of June. So your Lordship may kindly fix a date.
after vacation?
Vacation to one day.
Okay.
I read that.
Srimati Sujata, MS Sujata Jena, Senior Counsel, along with Mrs. Ponda. I'm sorry, I forgot your name. Sonali S. Ponda. Sonali Ponda for the petitioner. The Taran, a good batch. Mr. Tarananda Patnaik for the opposite party.
Opposite party 2 and 3.
One Mr. Prabhu Prasanna Behera, Additional Standing Counsel for OP1. Mr. Tarananda Patnaik, PP Behera, OP1. Mr. Tarananda Patnaik for OP2 and 3. The matter is listed for
Union of India.
कागज लिखी कागज दियो
Previous order अच्छे
Previous order
Actually, Union of India is a topic 5 in all the cases.
No, I have opened the other files.
That is in that way it can be copied also. समस्या ना अच्छी नहीं
सब डिटेल ठीक लिखा है
verify करते the same thing can be repeated practically.
37
2025 order number 2.
ଆପଣଙ୍କର ଗୋଟେ ଅର୍ଡର ହେଇଛି ଆଚ୍ଛା ଗୋଟେ କମନ କଷ୍ଟ ଆଇଟମ ହେଇଛି
ହଁ କମନ କଷ୍ଟ
ନା ସେଟା in subject देखिए सेटा खाली मिलन
महापात्र पेपर लेसे देखो मिस्टर राजेश
ମୁଁ ଦେଖୁଛି
my lords order number 14 my lords 61 2026
ସେଟା 14 ଟା 15 करेक्शन ହେଇଛି
my lords
ସେଥିରେ ଯାହା ଅଛି ସେଟା ଠିକ
stated clear ହବ କାରଣ ଫାଷ୍ଟ
order number 15 correction ହେଇଛି dated
61
2026
yes
common cost item କରି ସମସ୍ତେ ଲଗେଇଦେବେ the matter is listed for hearing under the heading for admission within court for admission. Paucity of time intervenes. The matter cannot be taken up. The matter cannot be taken up. Paucity of time intervenes. The matter shall be listed for admission in the week commencing
Week ନାହିଁ ଆପଣ ଗୋଟେ ଡେଟ୍ ଫିକ୍ସ
ଡେଟ୍ ହେଲେ ଆପଣଙ୍କର ଡିଫିକଲ୍ଟ ଆପଣ ଚାହାନ୍ତି ଲିଷ୍ଟିଂ ପାଇଁ ନା ଲିଷ୍ଟିଂ ନ ହବା ପାଇଁ
ନାଇଁ ମୁଁ ଲିଷ୍ଟିଂ ପାଇଁ
ମୁଁ ବି ଚାହେଁ ଲିଷ୍ଟିଂ ପାଇଁ ସେଥିପାଇଁ ୱିକଲି କରିକି ଆଇ ବିନ୍ ସକ୍ସେସଫୁଲ ଆପଣଙ୍କ ଜୁଡିସିଆଲ ଅର୍ଡରରେ ଥରେ ହେଇଗଲେ
ଆଗରୁ ଆଜ୍ଞା ଆପଣଙ୍କ କୋର୍ଟରେ ହଉଥିବ ଅନ୍ୟ କୋର୍ଟରେ ଆମେ ଯାହା ଫେସ୍ କରୁଛୁ ଆମକୁ
ନାଇଁ ମୋର ରେସ୍ପନ୍ସ ଇଜ ଗୁଡ
ତାହେଲେ ଠିକ ଅଛି
କମ୍ପ୍ଲିମେଣ୍ଟ ବି ମିଳୁଛି
ତାହେଲେ ଠିକ ଅଛି
ଅଦର ଆର୍ଟିଫିସିଆଲ କମ୍ପ୍ଲିମେଣ୍ଟ ହେଇପାରେ ବଟ୍ ମିଳିଯାଉଛି
ନାଇଁ ତାହେଲେ
ଯେ ରିଜନ ବିଂ ଧରନ୍ତୁ ଆଜ୍ଞା ସେ ଯୋଉ ଗୋଟେ ତାରିଖରେ କୋର୍ଟ ହଉନି କି ମୁଁ ଅଧା ବେଞ୍ଚ ବସିଲି ସେ ମ୍ୟାଟର ଆଉ ହେଇପାରିବନି ଦେ ଡୋଣ୍ଟ ହାଭ ଦ ଅଥରିଟି ଟୁ ଚେଞ୍ଜ ଦ ଡେଟ୍
that is true
ବଟ୍ ୱି କମେନ୍ସିଂ ହେଲେ ମୁଁ ତାଙ୍କୁ କହିଲି ଆଡଜଷ୍ଟ କରିଦେବେ ସେ ବି ଖୁସି ହଁ ଆଜ୍ଞା ଆଡଜଷ୍ଟ କରିଦେବି
ତାହେଲେ ଯୋଉଟା
ଲିଷ୍ଟ ବାଲା ବି ଖୁସି
ରିଓପନିଂ ର ସେଇ ଇଏରୁ
ହଁ ରିଓପନିଂ ର ନେକ୍ସଟ ୱିକ୍
ଆମେ ସେଇ ୱିକ୍ ରେ ଟିକେ କାଇଣ୍ଡ
ରିଓପନିଂ ୱିକ୍ ରଖନ୍ତୁନି ଦେयर ଇଜ ସମ୍ ୟୁଜୁଆଲି ଇଟ୍ शुड अवॉइड दैट लास्ट वीक आफ्टर द ओपनिंग इज ऑलवेज बेटर वी कमेंसिंग on 30
All the cases filed now. I have Union of India.
the learned counsel appearing for the opposite party submit that in some of the matters the opposite parties have not been solved with the rejoinder.
only Union of India
55
Okay, the learned counsel appearing for the Union of India in different cases submit that copy of the application, copy of the rejoinder filed by the petitioner. Response to their counter has not been served. Stop. The learned instructing counsel respondent shall ensure service of copy of the learned counsel appearing for the Union of India.
yes
In main item 1 and sub item 4,
Sir,
central government has not served copy on the.
okay. The learned counsel appearing for the University 2 and 3 and the learned counsel. ଆପଣ ପ୍ରଭୁ କି ବି ଦଉନାହାନ୍ତି ଆପଣ ବି ପାଇନାହାନ୍ତି କିଛି ହଉ
ନାଇଁ ସେମାନେ କିଛି ଫାଇଲ
ବିଧାନ ସାହେବଙ୍କର ଇନଷ୍ଟ୍ରକ୍ସନ ଅଛି ଜମା ଦବନି ଆପଣଙ୍କର କଣ ଦରକାର The learned counsel for the learned understanding counsel for OP1 and the learned counsel appearing for the university submit that the pleadings of the parties should be exchanged as the matter is being listed for admission hearing. Stop. The learned counsel for the appearing parties are requested to exchange the pleadings.
Yes,
Amongst the appearing counsel.
Yes. Right.
मेंशन गुडा का आपण पोस्टिंग कर देछंती और रेस्ट ऑफ द मैटर्स जोडा पेज वाइज जोडा चाहे डेट कोंतु आपण को जाय गले सीरियल 26 27 जाय 28 रो मिस्टर दास 28 यू वांट अ डेट जो दिन डेट से दे देबे ना डिलीट से चल ट्रांसफर ब्रीफ केजन सिंपली चाहजन डिलीट हे जाऊ मेंटेनेंस गुडा को चाहजन डिलीट हे गले भलो
ये नथिबे ना आइटम नंबर 28
वाइफ चाहजन रहू लिस्ट है हस्बैंड चाहजन डिलीट हे जाऊ केजन वाइफ चाहजन डिलीट हे जाऊ सो कॉम्प्लिकेटेड आपण केबे चाहजन आफ्टर वेकेशन लेले अब
29/6 मैडम
29/6 सो आई एम 13/7
जून मास मिसेरल
जून नहीं जून 29 ला अरे it starts with 29/6 then goes to Wednesday is 1/7
all like once
at times it gives a impression as if it is a month but it is only 2 days sorry 1 day rather 30 तारीख को गोटे दिन 13/7 तो 13/7 केबे कहले 13/7 6/7 रे 62 टा पड़ी 6/7 रखन दास चाहू
Lordship, item 30. I am the petitioner in this case, madam.
Whatever, sir. You are not passing any order. Simply posted in the computer.
Lordship, 28 रे मु opposite party transfer brief. I have been instruction to appear on behalf of Abhinash Acharya. He will file.
So just what you do, sir, write it a piece of paper. Since I am not passing any order, after I have stopped taking up, I should not. ताको दे दियो तो सेटा दे देबे
Item 32, I am requesting for the
29 कला just one second 32 30 sir 30 डेट कर दियो ठीक अछि 31 मिस्टर विश्वाल
Yes, that may fix. It will take time. That may fix.
31 after vacation get कर दियो yes
we commencing 13/7
we commencing 13/7
Order pass होवन पर एंट्री ऑर्डर अछि
नहीं आपनकर एंट्री ऑर्डर जदी पोस्टिंग डेट अछि ताल दरकार जदी स्टे नहीं आई एम नॉट टचिंग एनी
स्टे अछि
डे विल स्टे रिमेन स्टे
अछि
in some cases the order that
till like that
so it is there yes 32
Lordship, I am praying for the extension of the interim.
I am for the opposite party.
I am suffering with the interim order. Because at this stage of
Yeah,
argument,
adjournment order, जोटा जो final hearing.
at this stage of argument, any day before vacation, any day.
Any day before vacation adjourn नहीं
Very
होगा.
short point.
So whatever sir, it requires some hearing.
Any day before.
ଆପଣଙ୍କୁ ଆଜ୍ଞା along with Mr. Bhuya ତ ଗୋଟେ ଦିନ ପଳେଇବ.
Sir, point ଟା बहुत limited point ଅଛି एकदम छोटिया point. खाली ଗୋଟେ passport ଟା production ପାଇଁ ସେ actually, which is not necessary. I am not pressing that.
Sir, your name?
Shashwat Kumar Rao. I do not have power.
Shashwat Kumar Rao. Mr. Shashwat Kumar Rao on behalf of SS Bhuya for the petitioner. Mr. Manmoy Kumar Das for the से आप किसी दिन पर जमती बंशीधर शतपथी चेंज कर देला आपन को ब्रीफ नहीं दियो से किछि बुझु नांती कि बोले काय मैटर अर्जन होची
अच्छा सीट पे मो
से बंशीधर शतपथी एते मेंशन करछन ताका पे आपन विश्वास करियो କିନ୍ତୁ चेंज कर देला
टेक्निकल पॉइंट्स मेंटेनेंस
से जहां भी हो
प्रोसीड करे को चाहिए
एमती गोटे दिन नहीं जो दिन मिस्टर शतपथी विल नॉट मेंशन इट एंड से दैट लेट इट बी टेकन
मो कहूची 10 मिनिट भी जीवो काहे कि ना मो मेंटेनेंस प्रोसीडिंग टा ही प्रोसीड करिवि जो थारु आसी
सर 23 मैटर ता जगह रे आसीबो
बिफोर दिस इज माय सिंसियर प्रेयर
Sir, I'm most sincere that earliest date हवा दरकार. Mr. Nikhil appearance on behalf of SS Bhuya, Mr. Manmoy Kumar Das for the opposite party. Paucity of time intervenes. The matter is mentioned by the Lorded Counsel for the parties. It is submitted by the Lorded Counsel for the opposite party, Mr. Das, that the matter may be taken up for disposal, for taken up for admission, hearing and disposal. For hearing and disposal will be got stop. The Lorded Counsel for the petitioner refers to the earlier order. Upon keep it Mr. Das, that date I can give it to you. After vacation, what date select करो?
Totally, I will take my chance.
आपनकर जो चार्ज काहे कि आपन को कोआ जाउची on 11/5 110 टा अछि 18/5 रे अछि 100
लास्ट वीक रे
गोटे डेट रो 100 रे एडजस्ट हो
वीक कमेंसिंग विथ हाउस लास्ट वीक
ठीक अछि
इमीडिएट
earlier order dated 13/2/2026 and the subsequent orders extending the said order seeking adjournment of the matter before the court family court Bhubaneswar. Just family court Bhubaneswar. Stop. The matter shall be listed in the week commencing 18/5/2026. Upon a prayer being made for before the Learned Judge Family Court Bhubaneswar, the CP number 541 of 2021 shall be adjourned beyond 25/5/2026. We take as will be convening to the Learned Court in season of the matter. Yes. Listed for admission लिख लेता after 5. ठीक है. Yes.
33 लड़सी.
33 से Mr. Mahapat
Morning
mention कले हाँ.
हाँ करते I was not available. Later I came to know it is no adjourn. My presence may be required.
I'm not marking any presence.
that
आपन
is
Central
only-
Government Council.
No. Private.
Then it is not. No order is passed.
Grateful.
That saves time.
I'm just trying.
By doing it in computer, that saves time.
Lots.
Yes. 34, 35. 34, Mr. Samal, the Swine.
I am the opposite party.
So, after vacation. So 34 for the
Who comes with there, sir?
35.
Let's see,
You are 35.
37, let's see.
Just a second. 35 ठीक है चल 36 अर्जुन क्वेश्चन मेंशन करते हैं नहीं सर क्वेश्चन 37
My lord.
37 yes
Let's see, I am not the opposite party in this case. I have not received this notice issued by this Hon'Ble court. I am getting information from the court below. Then I will appear in this case.
37
My lord.
37 है Mr. Lenka, Mr. Dolai, Mr. Mohanta.
My lord. I am.
You are Mr. Lenka.
My lord.
So your name is there, sir.
Let's see.
से कॉपी देना जी पूछो
My lord.
No sir, सेटा तो अपन पर्सनल रिक्वेस्ट करियो पड़ियो. Unless it reaches, I can't direct. So you want it before vacation or after
Before vacation?
We commencing 18/5 करते. Yes. 38 को अपन मेंशन करते.
अच्छा 28.
28 अपन. अच्छा 38 ସବୁଟା mention ହେଇଥିଲା 38 39
39, 40, 41.
41 mention ହେଇଛି 28 sir yes 6 7
Any date prior to that.
again 6 7 is the fast date after second week after the opening week so obvious date करा हो in fact there is no reason ଆପଣଙ୍କର 6 7 I can tell you now ଆଜି की ଛାଡି की 62 ଟା ଅଛି so it has looking at the actual number of cases posted has some advantage because listing is not a problem but reaching is important for you also it is important thank you